ne défend pas la paix, nulle part. Je vais ici rappeler que la Russie est un allié historique et stratégique du régime de Téhéran, avec lequel elle a signé en janvier 2025 un accord de partenariat stratégique global, dont les détails n'ont jamais été révélés et qui se traduit notamment par la production en territoire russe de drones d'origine iranienne. Je le dis aussi pour bonne mémoire et pour que toutes les nations qui sont engagées en guerre contre l'Iran, ce qui n'est pas le cas de la France, je l'ai rappelé, mais soient cohérentes dans les positions tenues et qu'elles sachent avec qui ces drones sont produits. Personne n'ignore que le ciel ukrainien a malheureusement été un banc d'essai pour les drones iraniens qui tombent aujourd'hui dans le Golfe et sur certains de nos alliés. C'est pourquoi je sais que le président a raison, et je l'en remercie, a tout de suite souhaité soutenir ces nations et apporter les solutions ukrainiennes, votre innovation, vos capacités. En tout cas, dans ce moment que nous vivons, je le disais, notre engagement en faveur de l'Ukraine, nous le tiendrons. Car il en va de la sécurité de l'Ukraine, mais également de l'Europe et de la France. Dans le processus en faveur d'une paix juste et durable, l'Europe a un rôle de tout premier plan à jouer. L'Union européenne et ses États membres sont le premier contributeur à la résilience de l'Ukraine depuis le début de la guerre. Nous avons aussi décidé en décembre dernier d'un prêt de 90 milliards d'euros. Cet engagement sera tenu. Et je le dis ici avec force et clarté, si des désaccords s'expriment, c'est le devoir de chaque nation de tenir les promesses qui sont faites et les engagements politiques qui ont été pris par tous en décembre dernier. Le soutien que nous apportons, c'est aussi celui à travers la coalition des volontaires que nous avons lancée il y a maintenant un peu plus d'un an avec le Royaume-Uni, qui contribuera aux garanties de sécurité de l'Ukraine, aux côtés de nos partenaires des États-Unis d'Amérique, qui sont le pilier indispensable d'une paix juste et durable. Nous l'avons démontré le 6 janvier dernier, la planification est maintenant achevée et nous sommes prêts. Notre soutien s'incarne également dans notre appui à l'Ukraine pour avancer vers son destin européen, chemin vers l'adhésion exigeant qui implique des efforts et des réformes que vous conduisez. Et beaucoup a déjà été fait de manière impressionnante. L'Ukraine mérite d'ouvrir le premier bloc de chapitres de négociation et je n'ai de doute que nous y parviendrons, malgré les obstacles artificiels qui ont surgi. Et nous accompagnerons ce chemin. Je veux également citer notre coopération dans le domaine énergétique. La France restera pleinement mobilisée, notamment dans le cadre de notre présidence du G7, pour bâtir dès à présent une véritable stratégie énergétique de résistance. Nous avons, depuis janvier, livré beaucoup d'équipements. Nous avons coordonné dans le G7 une position, là aussi, efficace. Aux côtés de tout cela, il y a évidemment le soutien militaire que nous continuerons d'avoir. Nous avons une longue discussion avec le président et son équipe, et je veux dire ici notre détermination de continuer à fournir tous les équipements pour permettre à l'Ukraine de mener sa guerre de résistance légitime et pour le permettre de se défendre. Et donc nous allons accélérer sur certaines capacités et continuer d'innover aussi pour que la production soit plus rapide. Notre détermination est aussi complète à accroître la pression sur la Russie pour l'amener à s'asseoir de bonne foi à la table des négociations. Beaucoup a été fait avec les sanctions, je l'ai évoqué, et nous continuerons, et nous préparons le 20e paquet de sanctions. Et nous continuons les efforts contre toutes les formes de détournement. Et nous continuons aussi les efforts pour lutter contre la flotte fantôme qui, comme vous le savez, alimente l'effort de guerre russe. Nous avons eu des résultats très probants ces dernières semaines, avec des opérations en propre, l'opération que nous avons menée avec la Belgique. Nous avons engagé plusieurs autres nations qui ont conduit aussi des opérations déterminantes. Nous poursuivrons cet effort. Voilà, mesdames et messieurs, ce que je souhaitais dire ce midi en accueillant à nouveau le président Zelensky. Cher Volodymyr, dans le combat que vous menez pour votre liberté, votre indépendance, votre intégrité territoriale, vous défendez l'idée d'une paix juste et durable, la seule compatible avec le droit international, et vous menez un combat pour votre sécurité, mais aussi pour celle de tous les Européens. À ce titre, vous avez toujours votre place ici, et c'est toujours une fierté pour la France de vous accueillir. Merci beaucoup.
Дякую дуже.
Merci beaucoup.
Дуже дякую тобі особисто,
Je te
Еммануеле.
remercie beaucoup
Дякую за все.
personnellement, cher
Шановний пане
Emmanuel,
президенте,
pour
шановні
tout.
присутні,
Monsieur le
журналісти.
Président,
Я
chers
вдячний за
journalistes,
цей
chers
візит,
présents.
за всю
Je suis
підтримку
reconnaissant
Франції
pour cette visite,
для
pour tout le
України,
soutien
українців,
qu'apporte
за
la
твою
France à
особисту
l'Ukraine, aux
підтримку,
Ukrainiens,
Еммануеле.
pour ton soutien
Ми в Україні
personnel,
все це
Emmanuel. En Ukraine,
знаємо
nous le
і дуже
savons,
цінуємо і також цінуємо, що завжди можемо координуватись з Францією та в багатьох питаннях бути однодумцями. Це так важливо, особливо під час війни. Сьогодні ми говорили з Еммануелем, з його командою, вдячні також колегам. Передусім говорили про безпеку, нашу безпеку України, Європи, безпеку глобальну з точки зору подій на Близькому Сході та в регіоні Затоки. Напередодні в Іраку через іранський удар загинув французький військовий. Прийміть, будь ласка, співчуття від мене особисто, мої співчуття всіх українців, рідним та близьким. Були також поранені солдати, ми сподіваємось на швидке одужання. І для усіх в світі це дуже важливо, щоб завдяки спільним зусиллям вдалося стабілізувати ситуацію та не допустити ширшого розгортання ще й цієї війни. Усі бачать втрати життів, усі бачать руйнування, загрози для різних країн регіону, усі бачать дестабілізацію глобальних ринків через фактично зупинку руху через Ормузьку протоку. Можуть бути різні оцінки цієї американської кампанії проти іранського режиму, але будь-кому складно сперечатися із тим, що цей режим в Ірані терористичний, і цьому регіону, і самому Ірану точно потрібно значно більше поваги до життя і більше захисту життя, передусім від цього режиму в Ірані. Україна може зробити внесок в стабілізацію. Вже більше 10 країн звернулись до нас за підтримкою в захисті від шахедів іранських ударних дронів. Це фактично ті ж ударні дрони, які іранський режим передавав Росії і навчав росіян застосовувати їх проти мирного населення України. Зараз ми в Україні маємо найбільшу в світі експертизу в протидії шахедам через цю війну, безумовно, через ці масовані атаки. Це і створення перехоплювачів, це наші нова наша експертиза і системний захист від дронів, передусім іранських. Недостатньо просто отримати десь перехоплювачі, треба, щоб був досвід їхнього застосування. Такий досвід є у наших воїнів, має бути відповідна системна робота з радарами, досвід заради безпеки тих партнерів, які нам допомагають. Звісно, ми проговорили це і з Еммануелем, і звісно, ми будемо всі координувати наші дії. Звісно, ми вважаємо, що в Європі потрібно реалізувати такі, демонструють, що таке сучасна війна, які є загрози, якою має бути взаємодія партнерів заради захисту. Ми з президентом Франції про це теж ми говоримо детально і готові працювати разом з Францією. Важливо, щоб лідерство Франції було в таких спільних захисних проєктах для Європи. Звісно, і сьогодні, і завжди у нас предметна координація з Еммануелем по питаннях нашого захисту в Україні, нашої оборони. Еммануель точно Європу, Україна вдячна за оборонну підтримку Франції впродовж всіх цих років. І сьогодні ми визначили кроки і конкретні рішення, які можуть дати сильні результати. Це стосується і ППО, і бойової. Історична подія, я тобі дуже вдячний, Еммануель. Зараз лідерство Франції може бути багато в чому вирішальним, також і для майбутнього вступу України в Європейський Союз. Ми говоримо про можливі формати, має бути, принаймні, ми дуже цього хочемо, щоб у Росії не було просто жодної можливості блокувати Україну через російських спільників десь тут, в Європі. Важливо і надалі продовжувати тиск на Росію за цю війну. Заради досягнення справжньої безпеки і тривалого миру треба подолати блокування 20-го пакету санкцій ЄС проти Росії. Еммануель про це вже сказав. І тим більше на фоні рішень Америки про часткове послаблення санкцій проти російської нафти, яка зараз перебуває на танкерах в морі. Тільки одне це послаблення з боку Америки може дати Росії на війну суму близько 10 мільярдів доларів. Це точно не допомагає миру. І тому рішучість Євросоюзу, рішучість інших партнерів в світі зараз має зберігатись має працювати так, щоб у Росії не було додаткових ілюзій. Росія повинна завершити цю війну. Я вдячний кожному, хто нам з цим допомагає. Ще одне, для нас важлива підтримка в питанні про пакет 90 мільярдів євро для України на 2 роки. Це фінансова гарантія безпеки для нас. І зараз напередодні зустрічі європейських лідерів в Брюсселі наступного тижня ми координуємо наші позиції, щоб вийти на розблокування цих коштів. Коли Росія зараз фактично отримує додаткові ресурси завдяки черговій дестабілізації, Україна має отримати те, по чому Європа вже ухвалила рішення. Важливо, щоб рішення Європи працювало. Франція у нас в цьому підтримує. Дякую тобі за це, Еммануель. Дякую. Слава Україні.
Je crois qu'il est prévu que nous prenions 2 questions. Je vous en prie, Monsieur Ricard.
Bonjour, Philippe Ricard pour Journal Le Monde. D'abord, une première question à messieurs Macron et Zelensky sur la question des sanctions contre la Russie et ses exportations de pétrole. Vous avez rappelé, monsieur Macron, le consensus apparent au niveau du G7, comme quoi il fallait rester unis et maintenir ces sanctions. Or, on voit depuis 2 jours ou même 3 des dérogations américaines qui permettent le transport en fait de livraison sur certains bateaux, livraison russe de pétrole. Est-ce que ça veut dire que le président Trump est un adepte du double langage sur le sujet? Je voulais avoir votre réponse, messieurs Macron et Zelensky. Et puis une autre question liée à l'hommage que vous rendiez aux soldats français morts aujourd'hui en Irak. À propos de ce décès et des blessés français qui restent là-bas, d'ici à combien de temps pensez-vous être en mesure d'organiser une riposte, monsieur Macron? Est-ce qu'il n'y a pas le risque avec cette riposte d'entrer dans une forme d'engrenage guerrier dans la région, à la fois en Irak, mais aussi en soutien des Émirats arabes unis qui sont éminemment touchés par la réplique iranienne, et connaître, monsieur Zelensky, quelles sont en détail l'aide que vous apportez déjà aux pays du Golfe menacés par les frappes iraniennes. Merci.
Merci beaucoup. Pour ce qui est des sanctions, il est tout à fait juste que les États-Unis d'Amérique ont acté des dérogations limitées dans le temps et les conditions et pour quelques pays. Le ministre de l'économie, des finances, le secrétaire d'État au Trésor américain s'est exprimé pour lui-même rappeler le cadre très limité de ces exceptions et leur impact réduit, et rappeler que les sanctions demeuraient. Et pour ce qui est du G7, la position commune a bien été le maintien des sanctions à l'égard de la Russie, et pour ce qui est des Européens et de la France, c'est le maintien des sanctions. Et la situation ne justifie en rien de lever ces dernières. Donc je considère que ce que je vous ai dit tout à l'heure reste valable et que la décision qui a été prise de manière exceptionnelle et limitée par les États-Unis d'Amérique, c'est à eux de la justifier, mais elle ne revient pas de manière durable et large sur les sanctions qu'eux-mêmes ont décidées. Et à les écouter, et le président, dans les discussions que j'ai pu avoir avec lui et dans leurs propos publics, ils ne remettent pas en cause cette approche. Pour ce qui s'est passé ces dernières heures en Irak, au-delà de ce que j'ai pu vous dire à l'instant, je serai très prudent et j'attends d'avoir tous les éléments qui me seront fournis par l'état-major des armées et nos services, et j'attends de pouvoir parler avec le Premier ministre irakien. Je n'élaborerai aucune forme de scénario, ni n'entrerai dans quelque politique fiction sur ce sujet. J'ai rappelé la position de la France. Elle est claire dans la région. Elle est défensive. Nous ne sommes pas engagés en guerre contre qui que ce soit. Nous avons une présence dans la lutte contre le terrorisme, dans un cadre qui est connu, et c'est le cadre en Irak, dans lequel se battait notre soldat. Et nous sommes là pour protéger nos ressortissants, nous sommes aux côtés de pays alliés avec lesquels nous avons des accords de défense, et nous sommes présents pour participer à la liberté de navigation et sécurité maritime dans la région. C'est tout. Mais nous assumons ces missions pleinement, avec les risques qu'elles comportent.
Дякую за запитання. Санкціями
Merci beaucoup pour cette question. Je pense que Emmanuel a traité déjà la question des sanctions. Et moi, je pense que la levée de sanctions, même temporaire, va renforcer la position de la Russie. Ça va lui permettre d'avoir des financements, parce que la Russie supplémentaire pour financer la guerre, parce que tout est converti dans cette logique martiale. Je pense que cette logique, la logique est de favoriser la restabilisation, mais la logique est contraire en réalité quand on regarde, parce que plus la Russie a de l'argent pour financer sa machine de guerre, plus il y a également des drones qui sont fabriqués sur le sol russe pour déstabiliser le Moyen-Orient. Donc lever les sanctions pour fournir plus d'argent, pour recevoir plus de drones sur les frappes de drones sur territoire, ce n'est pas très logique. En ce qui concerne notre aide aux pays du Moyen-Orient, nous avons été approchés par certains pays du Moyen-Orient pour partager notre expertise concernant notre lutte contre les drones Shahed, les drones de fabrication iranienne. C'est justement ce type de drone qui est utilisé et nos groupes d'experts ont été envoyés dans les 3 pays du Golfe et nous sommes prêts à aider.
Вітаю. 1+1 Україна, телеканал. У мене запитання до пана Макрона. Пане Макроне, напередодні ваші радники заявили, що Франція готова відокремити питання кредиту від ситуації довкола нафтопроводу «Дружба». І нагадаю, що ці домовленості були досягнені у грудні на Європейській Раді. Якщо, зрештою, питання з нафтопроводом, якщо транзит не відновиться, то чи є якийсь план Б, якийсь вихід, як вийти з цього глухого кота і допомогти з
solution pour sortir de ce blocage et aider l'Ukraine dans cette question de crédit. Question au président ukrainien, est-ce qu'il y a déjà des résultats du travail de notre équipe au Proche-Orient? Vous avez déjà évoqué le fait qu'il y a des pays qui sont prêts à travailler avec l'Ukraine sur les questions militaires. De quel pays s'agit-il de la vente des armes à ces pays? Merci pour cette question.
В кінці тижня військові і секретар РНБО повернуться, і буде доповідь повна. Ми маємо запит на сьогодні від 6 країн щодо допомоги. Експертизу ми відправили в 3 країни, і окремо є запитання щодо американської сторони, окремо запитання щодо Йорданії. І запит, вибачте, щодо Йорданії. Вони повернуться, будемо розуміти обсяг тієї допомоги, яку очікують від нас партнери. Безумовно, те, що я сказав про дрони-перехоплювачі, частково я сьогодні говорив про це під час виступу і також проговорювали це з Еммануелем. Ми знаємо, що в країнах і близькосхідних, і Сполучених Штатах Америки є відповідна кількість дронів-перехоплювачів. І в європейських державах так воно буває, так, але без наших пілотів, без військових, без спеціального софта, все це не працює. Ця система є тільки у нас, вона офіційна, є в Збройних силах України, і тому всі розуміють, навіть маючи десятки і сотні перехоплювачів, вони, чесно кажучи, ситуацію не вирівнюють. Це системний захист. Саме експерти, які експерти в системному захисті, профі ППО, застосування малої ППО, саме вони і полетіли в ці країни близького
de petite et de moyenne envergure, et c'est eux qui sont allés.
Merci beaucoup. Je vais répondre à la question qui m'a été posée par Madame la journaliste. Ce qui s'est passé à Druzhba, nous en avons parlé avec le président, j'en ai pu en parler un peu plus tôt cette semaine avec Madame la Première ministre qui était en France pour le sommet nucléaire. Il est important que d'abord toute la transparence soit faite, et les efforts de la présidente de la Commission sont tout à fait positifs à cet égard, et que les travaux soient faits au plus vite, et je sais l'engagement pris par l'Ukraine en la matière, et je pense qu'il faut apaiser le débat sur ce qui s'est passé. Donc la transparence, la rapidité des travaux pour apaiser le débat. Mais ceci n'est c'est un sujet en soi, si je puis dire. La décision des 90 milliards de prêts, c'est une décision que nous avons prise ensemble par rapport à un contexte de guerre qui n'a pas changé. Et donc nous devons tenir les engagements pris, la décision prise. Voilà. Et donc c'est ce à quoi nous allons travailler dans les jours et les semaines qui viennent. Je sépare les deux sujets et j'ai la même détermination sur les deux sujets. On doit tenir notre parole. Et donc les 90 milliards, nous devons le faire dans les conditions définies en décembre dernier. Druzhba doit être réparé au plus vite et toute la transparence doit être faite pour apaiser les choses. Merci beaucoup.
Merci beaucoup.
Merci à vous. Merci mesdames et messieurs.
Thank you so much.
Mr. Secretary General, distinguished ambassadors and representatives of the international community.
السيد الأمين العام، أصحاب السعادة، السفراء، السيدات والسادة ممثلي المجتمع الدولي، السيد الأمين العام، أود أن أعرب لكم عن خالص تقديري لوقوفكم إلى جانب لبنان في هذا الظرف الدقيق. إن وجودكم بيننا اليوم في بيروت يبعث برسالة تضامن قوية وواضحة في لحظة يواجه فيها بلدي أحد أخطر فصول تاريخه الحديث. خلال زيارتكم الأخيرة إلى لبنان في كانون الثاني الماضي تحدثتم عن الأمل وقلتم إن النافذة قد فتحت تمهد الطريق لعصر جديد من الاستقرار المؤسسي. غير أن هذه النافذة التي بشرت بالأمل باتت اليوم مهددة بالإغلاق، وكما أشرتم قبل أيام قليلة يجد الشعب اللبناني نفسه مرة أخرى في مرمى النيران، والحقيقة أنه صراع لم يختره وصراع لم يرده. في الأسابيع القليلة الماضية أجبر أكثر من 900,000 إنسان، أي ما يقارب 1 من كل 5 مقيمين، على النزوح من بيوتهم والبحث عن ملجأ يأويهم على امتداد الأراضي اللبنانية مع اشتداد العمليات العدائية. وفي جنوب لبنان تفرغ قرى وبلدات كاملة من سكانها بين ليلة وضحاها، والعائلات تهرب من منازلها حاملة ما تيسر، والمدارس تحولت إلى مراكز إيواء، والمستشفيات تعمل فوق طاقتها مثقلة بالمصابين والمرضى، والخدمات الأساسية تتعرض لضغط هائل. قتل المئات وأصيب الآلاف، وخلف كل رقم قصة طفل أو أب أو أم أو عائلة انقلبت حياتها فجأة رأسا على عقب ووجدت نفسها في مواجهة ظروف قاسية. مجتمعنا أنهكته سنوات طويلة من الأزمات والصراعات المتواصلة، ويجب نفسه اليوم على حافة ما يفوق قدرته على الاحتمال. إن الحروب الحديثة أخذت تمحو القواعد التي كانت تضبط النزاعات في الماضي، وعندما تنهار هذه الحدود ما من مكان آمن. التمييز بين المقاتلين والمدنيين وهو حجر الأساس في القانون الدولي الإنساني بات مهددا وأصبح أقل وضوحا. ودعوني أؤكد ما يلي، أنه عندما في هذه لا يمكن لأحد أن يشعر بالأمان. اسمحوا لي أن أكرر السيد الأمين العام، العائلات التي اضطرت إلى مغادرة منازلها والنوم في الشوارع أو في سياراتها أو في مراكز إيواء مكتظة لم تختر هذه الحرب. الأطفال الذين يستيقظون كل صباح على مشاعر الخوف من غارة مفاجئة قد تطال جارا أو عابر سبيل أو مدرسة لم يختاروا هذه الحرب، ولا يجوز أن يتحملوا عبء معاناة فرضت عليهم. لا مبرر لاحتجاز شعب أكمله رهينة. شعب لبنان ليس ساحة معركة، ومستقبل لبنان ليس أضرارا جانبية. إن وقفا فوريا لإطلاق النار ليس خيارا سياسيا فحسب، بل ضرورة إنسانية ملحة، والقتال يجب أن يتوقف، وعلينا حماية المدنيين واحترام القانون الدولي الإنساني احتراما كاملا. أصحاب السعادة، إن حكومتي مصممة على استعادة سلطة الدولة اللبنانية على كامل أراضيها وعلى حصر السلاح بيد الدولة وحدها، وقد اتخذنا بالفعل خطوات حاسمة في هذا الاتجاه لضمان أن تكون الدولة وحدها صاحبة الحق الحصري في حمل السلاح. وقد قام الجيش اللبناني بالفعل بتفكيك أكثر من 500 موقع عسكري ومستودع أسلحة جنوب نهر الليطاني، وذلك في إطار خطة شاملة تهدف إلى حصر السلاح تحت سلطة الدولة وحدها. كذلك اتخذت الحكومة قرارا واضحا بحظر جميع الأنشطة العسكرية والأمنية لحزب الله وجميع الجهات غير الحكومية، لبنانية كانت أم غير لبنانية، مع دعوة جميع الأطراف إلى تسليم أسلحتها إلى الدولة وحصر العمل السياسي ضمن الأطر الدستورية والقانونية. وهذه الإجراءات ليست خطوات رمزية، بل خطوات عملية تهدف إلى بناء إطار أمني وطني موحد ومستقر. وفي الوقت ذاته عززنا التدابير الأمنية والرقابية على الحدود في مطار بيروت الدولي على الطرق الحيوية حماية لمواطنينا ولشركائنا الدوليين. وقد اتخذت الأجهزة الأمنية أيضا إجراءات حازمة بحق الذين اعتدوا على قوات اليونيفيل، تأكيدا على التزامنا الراسخ بحماية شركائنا الدوليين الذين يدعمون استقرار لبنان. على الصعيد الدبلوماسي، جددت التأكيد على استعداد لبنان استئناف المفاوضات مع إسرائيل تحت رعاية دولية وبمشاركة مدنية. واليوم مع استمرار هذه الحرب يقف لبنان على حافة هاوية إنسانية، ومن دون تعبئة سريعة وفعالة للدعم الدولي فإن التداعيات الإنسانية مرشحة للتفاقم بشكل كبير في الأيام والأسابيع المقبلة. من هنا فإنني أدعو المجتمع الدولي إلى الوقوف إلى جانب لبنان، ليس فقط بكلمات التضامن على أهميتها، بل من خلال تحرك سياسي وإنساني حاسم. نعم، نحن بحاجة عاجلة إلى مساعدات إنسانية منسقة من إمدادات طبية وغذاء ومأوى ووقود لضمان استمرار عمل البنى التحتية الحيوية، لكننا نحتاج أيضا إلى جهد دبلوماسي متواصل لوقف التصعيد وإلى دعم يعيد الاستقرار إلى لبنان ويعيد إحياء الأمل بإمكانية تحقيق سلام عادل ودائم في منطقتنا. السيد الأمين العام، السيدات والسادة، بالنسبة إلى لبنان هذه لحظة بقاء، بالنسبة إلى المجتمع الدولي هذه لحظة مسؤولية، ولنتذكر دائما أن التاريخ لن يحكم علينا بما نقوله من كلمات بل بما نزرعه من أمل. أشكركم مجددا لوقوفكم إلى جانب لبنان اليوم. شكرا لكم جميعا. أصحاب السعادة، حضرة الزملاء والشركاء، أنا هنا اليوم في زيارة تضامن مع شعب لبنان. إن التضامن بالكلمات يجب أن يقترن بالتضامن بالأفعال، ولهذا يسعدني أن أنضم إليكم اليوم لإطلاق نداء إنساني عاجل بقيمة 325 مليون دولار أمريكي لدعم شعب لبنان. هذه المساعدة مطلوبة بشكل طارئ. إن التصعيد العسكري في مختلف أنحاء المنطقة يخلف خسائر فادحة بما في ذلك في لبنان، فقد قتل مئات المدنيين هنا في لبنان، بينهم عدد كبير من الأطفال، وقد طلعت مجتمعات بأكملها من أماكنها، وانقلبت حياة الناس رأسا على عقب، وأصبحت أوامر الإخلاء تمتد اليوم إلى مناطق أوسع في البلد أكثر من أي وقت مضى، كما تعرض الوصول إلى الغذاء والمياه والرعاية الصحية والتعليم والخدمات الأساسية لاضطراب خطير. وقد نزح أكثر من 759 ألف شخص داخل لبنان، كما عبر أكثر من 90 ألف شخص معظمهم من السوريين إضافة إلى لبنانيين إلى سوريا. وفي ظل هذه الاضطرابات شاهدنا شجاعة وتضامنا استثنائيين على الأرض. فتحت المدارس أبوابها لإيواء العائلات النازحة، ويواصل العاملون في القطاع الصحي تقديم خدماتهم تحت ضغط هائل، وتظهر المجتمعات المحلية قدرة كبيرة على الصمود حتى بعد أن نزحت مرارا وتكرارا. تعمل هيئات الأمم المتحدة وشركائها الإنسانيون بشكل وثيق مع السلطات المحلية للاستجابة بشكل عاجل من خلال توفير الوجبات الساخنة ومياه الشرب الآمنة ومستلزمات النظافة والمواد الغذائية الأساسية. وهذه الجهود تنقذ الأرواح، ولكنها تحتاج أيضا إلى دعم أكبر بكثير. إن النداء الإنساني العاجل الذي نطلقه اليوم سيسهم في الحفاظ على المساعدات المنقذة للحياة وتوسيع نطاقها خلال الأشهر الثلاثة المقبلة، بما يشمل الغذاء والمياه النظيفة والرعاية الصحية والتعليم والحماية وخدمات حيوية أخرى. ويعتمد نجاح هذا النداء على توفير التمويل السريع والمرن وضمان تمكن العاملين في المجال الإنساني من الوصول بأمان إلى من هم بأمس الحاجة إلى المساعدة. واسمحوا لي أن أختتم بهذه الملاحظة. في مختلف أنحاء البلاد الآن تصوم العائلات المسلمة في شهر رمضان المبارك، فيما تحيي العائلات المسيحية زمن الصوم الكبير، وهذه مواسم تقوم على الرحمة والعطاء وتعكس روح شعب لبنان الحقيقية. فلسنوات طويلة فتح لبنان أبوابه أمام الهاربين من النزاعات، وقد أظهر شعب لبنان للعالم المعنى الحقيقي للضيافة والتضامن والصمود. والآن على العالم أن يظهر لشعب لبنان أقوى أشكال الدعم في هذه الساعة العصيبة من الخطر والحاجة العميقة. هذه احتياجات طارئة وفورية، ولكن سيحتاج لبنان إلى الكثير على صعيد التضامن من جانب المجتمع الدولي من خلال المساعدة على وقف إطلاق النار فوري يقبله الطرفان وإيجاد الظروف المناسبة لإطلاق مفاوضات من شأنها أن تسمح للبنان بأن يصبح في أسرع الأجال بلدا تحترم فيه سيادة الأراضي ويكون للدولة أيضا حصرية استخدام القوة. الأمم المتحدة مستعدة لدعم الحكومة اللبنانية في هذا البرنامج الشجاع المطروح أمامكم. شكرا جزيلا. شكرا لك السيد الأمين الأعلى. وبعد إذنك أود أن أعطي الكلمة لمعالي وزيرة الشؤون الاجتماعية السيدة حنين السيد، صاحب السعادة الأمين العام للأمم المتحدة، أصحاب السعادة، حضرة الشركاء الموقرين، السيدات والسادة، شكرا لحضوركم اليوم في لحظة بالغة الإلحاح بالنسبة إلى لبنان. خلال الأيام الماضية قمت بزيارة مراكز الإيواء الجماعية في مختلف أنحاء العالم، والتقيت بعائلات اضطرت إلى مغادرة منزلها بما تيسر لها، آباء يحاولون طمأنة أطفال خائفين، وكبار في السن يحتاجون إلى استمرارية الرعاية، وأشخاص من ذوي الإعاقة يواجهون تحديات خاصة غالبا ما يتم تجاهلها في حالات الطوارئ. للأسف هناك اليوم ما يقارب 1,000,000 شخص في حالة نزوح، ويقدر أن تؤثر هذه الأزمة على 1.3 مليون شخص، ويقارب نصف المتأثرين بالأزمة من الأطفال، وأكثرهم من أكثر من نصفهم من النساء والفتيات. غير أن قصة هذه الأزمة الإنسانية لا تقتصر فقط على النازحين، ففي مختلف أنحاء لبنان تحملت المجتمعات المحلية والبلديات والمدارس والعائلات صدمة هائلة، وقد فتح الناس أبواب منازلهم وتقاسموا ما لديهم وأظهروا تضامنا استثنائيا. وخلال ساعات من التصعيد في الأول من أذار فعلت حكومة لبنان استجابتها الطارئة بالتنسيق المركزي من السراي الحكومي الكبير تحت قيادة رئيس مجلس الوزراء مع فروع تنفيذية منتشرة في جميع المحافظات، ويتم تنفيذ الاستجابة بالتنسيق الوثيق مع وكالات الأمم المتحدة والشركاء الإنسانيين. واليوم أصبحت مؤسسات الدولة معبأة بالكامل على الأرض، بما في ذلك 2600 معلم و600 عامل اجتماعي و6800 عنصر من الدفاع المدني، إضافة إلى فرق الصحية وفرق البلديات في 24 قضاء. إن جهود الاستجابة التي نقوم بها ليست ارتجالية، بل تستند إلى أنظمة قائمة وبيانات آنية وآليات تتيح التعبئة السريعة للمساعدات استنادا إلى الاحتياجات المحددة، وتسمح لنا هذه الأنظمة بتحديد أولويات الدعم حيث يكون الأكثر إلحاحا وضمان استخدام الموارد بكفاءة وشفافية. وقد تم توسيع القدرة الاستيعابية للإيواء من خلال استخدام المرافق العامة، كما أن الوصول إلى هذه المراكز متاح للجميع، ونحن نعمل بشكل وثيق مع شركائنا لتحسين ظروف الإيواء وتعزيز إمكانية الوصول، ولا سيما للأشخاص ذوي الإعاقة والفئات الأكثر ضعفا. وتبذل جهود أيضا لتوسيع نطاق شبكة الأمان الاجتماعي المستجيبة للصدمات بهدف تقديم مساعدات نقدية للعائلات لتلبية احتياجاتها العاجلة مع دعم الأسواق المالية. إن الشفافية أمر أساسي، ولذلك نستثمر في أدوات جديدة ونعمل على تحسين التنسيق من خلال التسجيل المركزي وتطوير أنظمة البيانات وتعزيز آليات تتبع إيصال المساعدات لضمان أن يتحول كل دعم إلى أثر ملموس للأشخاص الذين هم في أمس الحاجة إليه. أصحاب المعالي والسعادة، سيدات والسادة، يأتي هذا التصعيد في لحظة من الهشاشة العميقة بالنسبة إلى لبنان، وقد بدأ بلدنا بالكاد يستعيد زخما متواضعا بعد سنوات من الأزمات المتتالية، وهذه الطوارئ تهدد بعكس مسار التقدم الذي تحقق بشق الأنفس وتعميق الفقر أكثر وزيادة الضغط على الخدمات والمجتمعات التي تعاني أصلا من أعباء كبيرة. من هنا أهمية النداء العاجل، فهو ليس مجرد طلب للتمويل، بل هو إطار لاستجابة منسقة تحمي الناس اليوم، فيما تعزز الأنظمة الوطنية التي تبقى ضرورية حتى بعد انتهاء هذه الأزمة. نحن نتحرك اليوم واضعين المستقبل في الاعتبار، فعندما تنتهي هذه الطوارئ ينبغي أن يتمكن الناس في جميع أنحاء لبنان من أن ينظروا إلى الوراء بفخر ويقولوا قالوا إن حكومتهم وقفت إلى جانبهم وبذلت كل ما في وسعها للاستجابة لاحتياجاتهم وصانت كرامتهم في أصعب الأوقات. هكذا يعاد بناء الثقة من خلال الظهار بالفعل لا بالقول أن الدولة تبقى شريكا موثوقا ومسؤولا تجاه شعبها. إن دعمكم لنداء العاجل اليوم لا يقتصر على تلبية الاحتياجات الإنسانية العاجلة والملحة، بل أيضا بالحفاظ على الاستقرار وحماية الكرامة وإعادة الأمل لملايين الأشخاص في لبنان، والتأكيد على أن الحكومة تبقى المصدر الأساسي للحماية والأمان. شكرا. شكرا. والكلمة الآن لمنسق الشؤون الإنسانية في لبنان السيدة عمران ريزا. شكرا جزيلا حضرة رئيس الحكومة، أصحاب المعالي والزملاء والشركاء والأصدقاء الكرام. كما شدد الأمين العام للأمم المتحدة وكذلك رئيس الحكومة ووزيرة الشؤون الاجتماعية، فإن الأثر الإنساني للتصعيد الحالي مدمر. تتعرض مجتمعات في المحافظات المتأثرة بالنزاع لنزوع متكرر وفقدانها لسبل العيش وتعطل الخدمات الأساسية، وهذا وطال العنف المدارس والمرافق الصحية والمنازل، مما أعمق معاناة أشخاص الأكثر ضعفا إلى حد كبير. وبحسب تقديراتنا المشتركة فقد تأثر نحو 1.3 مليون شخص من هذه الأزمة، ومنهم من نزح ما يصل إلى 1,000,000 شخص داخل لبنان، وعبر ما يقارب 100,000 شخص الحدود باتجاه سوريا. وتؤكد هذه الأرقام حجم الأزمة وأبعادها الإقليمية. وكما أوضحت معالي الوزيرة السيد نيابة عن الحكومة اللبنانية، فإن المؤسسات الوطنية هي التي تقود الاستجابة الطارئة، ودورنا كشركاء في الشأن الإنساني هو الوقوف إلى جانبهم بثبات بغية تعزيز قيادتهم عبر توفير الموارد والخبرات اللازمة والحرص على تضامن المجتمع الدولي. يحدد النداء العاجل الذي نطلقه اليوم الاحتياجات التمويلية والأولويات التشغيلية اللازمة لمعالجة أكثر الاحتياجات الإنسانية إلحاحا لما يقارب 1,000,000 شخص، وذلك لفترة ال3 أشهر المقبلة. نيابة عن فريق العمل الإنساني في لبنان والشركاء العاملين في المجال الإنساني من هيئات أممية ومنظمات غير حكومية وطنية ودولية، نطلب تمويلا بقيمة 300 مليون دولار أمريكي بهدف تقديم المساعدات المنقذة للحياة والمستديمة للحياة. فبدون هذا الدعم لا يمكننا توسيع نطاق الاستجابة لتلبية الاحتياجات المتزايدة، وعليه تركز استجاباتنا المشتركة على 3 أولويات استراتيجية. أولا، تقديم المساعدات المنقذة للحياة على مستوى مختلف القطاعات وبالوقت المناسب للمتأثرين بالأعمال العدائية، خصوصا العائلات النازحة المقيمة في مراكز الإيواء والمجتمعات المضيفة والمناطق المتأثرة بالنزاع. ثانيا، تعزيز حماية المدنيين والبنية التحتية المدنية استنادا إلى القانون الإنساني الدولي وقوانين حقوق الإنسان، وذلك على نحو راسخ. ويجب ألا يكون المدنيون والبنية التحتية المدنية أهدافا على الإطلاق. ثالثا، دعم الاستجابة السريعة واستئناف تقديم الخدمات الأساسية في المناطق المتأثرة بالتصعيد بغية ضمان استمرار عمل الأنظمة الأساسية على الرغم من الأزمة. وخلال ذلك كله سوف نولي اهتماما ملحوظا لمبدأ الشمولية، بحيث نضمن دعم المجتمعات المضيفة إلى جانب العائلات النازحة، بالإضافة إلى أولئك الذين بقوا في المناطق التي يصعب الوصول إليها، وذلك حرصا على تلبية احتياجات الفئات الأكثر ضعفا وتخفيف التوترات. ولكي تنجح هذه الاستجابة يجب أن يتمكن العاملون في الشأن الإنساني من الوصول بشكل آمن وبطريقة يمكن توقعها وبما لا يشكل عائقا لوصولهم إلى الأشخاص المحتاجين. فالوصول إليهم ليس امتيازا بل هو ضرورة ملحة، وبدونه لن تتمكن المساعدات من الوصول إلى النازحين والمهاجرين، ولن يتمكن الأفراد المتأثرون بالأزمة من طلب المساعدة، لا سيما أولئك المقيمين في المناطق التي يصعب فيها الوصول إلى الاحتياجات الأكثر حدة. وتؤدي المنظمات المحلية والشركاء الوطنيون دورا حيويا ومحوريا في هذه الجهود المبذولة، فهم المستجيبون الأوائل والعاملون الموثوقون داخل المجتمعات والمفتاح الرئيسي لضمان المساءلة تجاه الأشخاص المتأثرين بهذه الأزمة. لذلك يعد تعزيز التموضع المحلي ركيزة أساسية في استجابتنا المشتركة بهدف ضمان تقديم المساعدات بسرعة حيثما تكون الحاجة ملحة. السيدات والسادة، إن الأرقام الأساسية موجودة في الملخصات المتوفرة في النسخة الورقية أمامكم، ويمكن الاطلاع على النداء السريع أو العاجل بنسخته الكاملة عبر زيارة الرابط الإلكتروني أو رمز الQR كود المشار إليه. ويتم إطلاق هذا النداء العاجل في ظل بيئة تمويلية محدودة بالفعل، فالشركاء العاملون في الشأن الإنساني يستجيبون إلى الاحتياجات بموارد مالية وبشرية محدودة ومخفضة مقارنة بما كانت عليه، وتسهم المخصصات الطارئة الأولية التي تم تخصيصها من الصندوق الإنساني للبنان والصندوق المركزي لمواجهة الطوارئ في البدء بعملية الاستجابة، إلا أن الحاجة إلى تمويل إضافي لا تزال ملحة وضرورية، فمن دونها لا يمكن توسيع نطاق الاستجابة لتلبية الاحتياجات المتزايدة. لذلك أدعو المجتمع الدولي إلى الاستجابة بسخاء وبالسرعة. معا يمكننا إنقاذ الأرواح وحماية المدنيين ومساعدة المجتمعات اللبنانية على الصمود في وجه هذه الأزمة بكرامة. شكرا. شكرا لك يا عمران. والآن أفتح باب النقاش، أفتح باب تناول الكلمة لحضرة الضيوف الكرام وأدعوهم إلى التحدث لدقيقتين كحد أقصى. تفضل.
Yes. Good afternoon, Mr. President. Yes, I'm the Italian ambassador to Lebanon.
أنا سفير إيطاليا في لبنان.
With reference to the solidarity in action you
بالإشارة إلى التضامن بالفعل وليس بالقول الذي ذكرته في كلمتك الاستهلالية، أود أن أعلن أن الحكومة الإيطالية قررت البارحة توفير مساهمة إضافية للبنان تصل إلى 10 مليون يورو، أي ما يوازي 11 مليون دولار. وجزء من هذه المساهمة مخصص لدعم النداء العاجل، فيما الجزء الآخر سوف يقدم إلى الصليب الأحمر وجهات أخرى من منظمات غير حكومية عاملة في لبنان. طبعا هذه المساهمة سيتم تنسيق صرفها مع الحكومة اللبنانية ومع منظومة الأمم المتحدة. وطبعا من المقرر أن تصل طائرة تحمل 30 طنا من المساعدات الأولية إلى مطار بيروت بالتعاون مع
We said like a longest traveler with it? That's it? Okay.
There's one other person, but I didn't recognize who it was.
Okay.
Someone walked me to
Okay. Okay, cool. Yeah.
type of a hearing is something that in itself can give rise to prejudicial pretrial publicity because of the fact that the evidence that's being brought forth during that hearing is going to be, by definition, prejudicial. And the court in Estes, this is Judge Clark's opinion, says, this is at page 535 of the Estes opinion, it is contended that this two-day pretrial hearing, that is the hearing to exclude the press, cannot be considered in determining the question before us. And the question before them is whether Mr. Estes was deprived of his right, federal constitutional right to a fair trial. And the court goes on, we cannot agree. Pretrial can create a major problem for the defendant in a criminal case. Indeed, it may be more harmful than publicity during the trial, for it may well set the community opinion as to guilt or innocence. Though the September hearing dealt with motions to prohibit television coverage and to postpone the trial, they are unquestionably relevant to the issue before us. All of this two-day affair was highly publicized and could only have impressed those present and also the community at large with the notorious character of the petitioner as well as of the proceedings. The trial witnesses present at the hearing as well as the original jury panel were undoubtedly made aware of the peculiar public importance of this case by the press and television coverage being provided and by the fact that they themselves were televised live and their pictures rebroadcast on the evening show. So that kind of captures why we had to bring this motion, because we don't want to be in a position of inflicting another wound on Mr. Robinson's right to a fair and impartial jury by republicizing either right now in arguing this motion or on the 17th when the court hears from us what the nature and extent of that pretrial publicity is.
Well, let me stop you right there, Bert, and
yes.
Mr. Bert. So you cite the Estes case, but Estes was overruled by Chandler v. Florida because in Estes there was an assumption of prejudice, but in Chandler it required the defense prove actual prejudice, and so it changed a little bit. Can you talk a little bit about that?
Yeah, certainly. The Chandler court, first of all, was asked to but did not overrule Estes. But what it did clarify, as the court just indicated, is that if the defendant wants to prove up a federal fair trial violation, it's his burden to prove prejudice. And the Estes court outlines that that can be done through an evidentiary hearing at which the defense would have the burden of showing, again, the factors under the James case, nature and extent of publicity, how it prejudiced the defense, whether there are reasonable alternatives. That's going to be the very purpose of the hearing, to comply with Chandler's mandate that we have the burden to prove that prejudice. And so we're going to be taking on that burden, and we think well establishing that we're entitled to the relief that we seek, which is some restriction on the type of prejudicial information that is flowing not only from the electronic media, but that electronic media being amplified by the widespread use of social media, which we discuss at length in the motion. I'm not going to get into the merits of the motion itself, but to address a concern the court had about, well, really Estes is no longer good law. Estes is cited favorably in Chandler. It's cited favorably in Hollingsworth versus Perry, which is the Supreme Court's most recent discussion of cameras in the courtroom. And the court is correct that Chandler put a gloss on it, that we have to show there is no presumption of prejudice, but there is a presumption of prejudice in regard to certain types of prejudicial pretrial publicity. And the clearest holding to that in that regard is the Schilling case. Schilling says there is no presumption of prejudice unless certain categories that the courts have recognized as prejudicial are proven, and then it's inherently prejudicial. And the example that Schilling cites is publicity about a confession. And it cites back to the Wilbert Rideau case, Rideau versus Louisiana, where the court reversed the conviction because the defendant's confession was broadcast prior to the trial. So we have that type of prejudicial pretrial publicity in this case, and it's outlined in the motion. And so, yes, if you don't have those categories of prejudicial pretrial publicity, you have to prove prejudice. But there are certain well-known categories that do give rise to a presumption of prejudice. And that's reflected also in Rule 3.6, which says there's certain things lawyers should not be commenting about. And so we'll show both that we have categories of prejudice that are recognized as presumptively prejudicial, and we'll show that beyond that, the overall picture of this case is one of extreme prejudicial pretrial publicity that justifies the kind of relief we're asking for. But how do we show that without re-inflicting the very harm that we're seeking to avoid here? And that's the purpose of our motion. And the main concern is the tendency in this case for the press to, first of all, highlight all of the prejudicial information in virtually every story they feature on the case, which has its genesis in the prosecution's initial press conference before the court imposed its publicity order. There was an extensive press conference which got before the public a great deal of the kinds of evidence which Rule 3.6 says should not be disclosed before the court had the occasion to enter that order. And then that evidence has been re-amplified, commented upon, so-called experts have been brought in, lip readers, body language experts, all of that is outlined in the motion. The kinds of reiteration of this prejudice that we're most concerned about, the best example of that in document 344, which is the reply brief on this closure issue. At page 6, there is a link to an article, and that article concerns a story by one of the media's clients in which they were supposedly reporting on a defense anticipated motion to modify the court's publicity order. And the story does not concern, it's a television story, and the court has to see it to understand what the issue is, but the story does not concern what the merits of the motion is. The story focuses on, let's repeat for our audience in a very dramatic fashion all of the prejudicial statements made by politicians from the president on down, characterizing Mr. Robinson as an animal, characterizing him as evil, characterizing him as deserving of the death penalty. And they string together all these quotes and rebroadcast them. And that's the kind of coverage that's, I cite that as one example. But if the court sat down and touched on all the links we have in the 305 motion, the court will see it's repeated over and over again. So we don't want to be in that position of putting in front of the court all of this prejudicial information, then having the press regurgitate it yet one more time and re-inflicting the wound that we're seeking to avoid. That same link to that same article is in document 305 at page 175. It's interesting that the media's answer to this which I'll discuss, but I think I first need to return for a minute to the Kearns case. To continue with the other points that I wish to emphasize from that case, the third point from that case is the standard that governs what we have to show. And the court, in the opinion, says we don't have to show a clear and present danger to Mr. Robinson's right to a fair trial, but a realistic likelihood of prejudice. That's the standard the court will apply. And if the court looks at the standard for excluding electronic media, it's similar: reasonable probability, reasonable likelihood of prejudice. That's the applicable standard the court will apply. And the court also outlines the procedure to be followed on the motion that we're conducting right now. That is the motion on the hearing of whether the proceeding should be closed. And the court says, first, the hearing on the motion for closure should be open to the greatest extent possible, referring to this hearing that we're conducting right now. And then the court says, second, if disclosure of the alleged prejudicial material is essential to the conduct of the hearing on the motion for closure, the court should first seek a voluntary agreement from the parties who wish to be present that they will not disclose the alleged prejudicial information until it is disclosed at the trial or the trial has concluded. Absent such an agreement, the court may close the courtroom in order to conduct in camera whatever proceedings cannot be conducted without disclosure of the allegedly prejudicial information. So as I read that, the court's referring to the people presently in the audience who wish to be present during this hearing today, and that if they can't promise that they will not use information that I want to disclose in support of the motion today, then the court should conduct procedures in camera. Now, is it necessary for me to disclose to the court what my prejudicial information is? The media says in their motion that they filed yesterday, which is, I don't think I have a docket number for this, but it's entitled News Media's Memorandum in Opposing Motion to Close Portions of the Hearing, which is filed on the 12th yesterday. I don't have the docket number. I'm sure the media does, if there is one. But what they say is it's really not necessary for me to disclose to the court all the prejudicial information that we're relying on to justify moving to close, because at page 2 they say, if the defense does not want to highlight certain information at the evidentiary hearing, it can choose not to. The information is already cited in the motion to exclude, so the court can find it there. That would be a good solution, except for the fact that the media is also opposing our request to keep the motion private. So it doesn't do us any good to refer the court to all the prejudicial information in the motion if the court accepts the media's position that that motion in itself has to be disclosed to the press. Because if it is disclosed, they're going to take that motion and they're going to reiterate all the highlighted prejudicial information in that motion, and again defeat the very purpose of filing the motion. A couple of other points that I wish to emphasize to the court. One is, in both the present motions that I'm talking about and the motions that Ms. Visser just responded to, the media and the state, and the state are in, and the media are mini-me's of each other on this issue. Their pleadings are virtually identical, which calls into question why the media is even a part of this hearing. The court has not yet decided whether they have standing on this particular issue. And in your December ruling, you said that we were not obligated to file with the media the motions concerning restricting electronic media. In their latest opposition to the closure motion, they discussed their standing. But one of the issues in standing is whether we need the voice not only of one media lawyer, but of two media lawyers, asserting the same position that the state, one of the parties in this case, is asserting. So you're being presented with three different lawyers arguing essentially the same position. And when the court denied intervention to the media in this case, it cited the Utah Supreme Court decision in Society of Professional Journalists of Utah versus Bullock. And there the court, Utah Supreme Court, addresses the issue of standing in detail. And there were multiple media agencies in that case. And one of the points the court makes is that although there are multiple media agencies, they're all representing the exact same interest. That is the interest of the public in open access to the proceedings, which is coincidentally the same interest the state is asserting in reference to this motion. So we do question whether the state even has standing, but
You mean the press?
I mean the press.
Right.
I'm sorry,
Okay.
I misspoke. But putting that aside, both the state and the media stress to the court that the court should deny the motion to close, should deny, obviously, the motion to restrict media access, and allow the kind of prejudicial publicity that has characterized the case to continue, because we can all sort it out at trial through venue, motions for change of venue, through voir dire, or motions to expand the jury pool. And I wanted, that issue is addressed in detail in our underlying motion, the lengthy motion. But just to highlight a couple of the points that we raised there, one of them is the Utah Supreme Court, in a case that Ms. Nestor is currently involved in, the Richens case, and this is cited in our motion, said that the court does not have the authority to expand the jury pool. So that remedy is not one the court can adopt. And in terms of the other remedies that are being suggested, neither the state nor the media cites what I think is a controlling case on this issue, which is Gentile versus State Bar of Nevada, which is 501 U.S. 1030, discussed in our motion. But there, Chief Justice Rehnquist, writing for the court, who is no fan of the criminal defendants, said, quote, even if a fair trial can ultimately be ensured through voir dire, change of venue, or some other device, these measures entail serious cost to the system. Extensive voir dire may not be able to filter out all of the effects of pretrial publicity. And with increasingly widespread media coverage of criminal trials, a change of venue may not suffice to undo the effects of statements such as those made by petitioner. So I don't know how many capital cases that media lawyers have been involved in, but for the last 40 plus years, I've done nothing but those trials. And I've been involved with using jury questionnaires, extensive individual sequestered voir dire. And the fact of the matter is that voir dire is not an effective means in these cases. And to the extent it is effective in excluding people who hold prejudicial opinions, it calls into question other rights that are implicated. For instance, in a death penalty case, the jury has to be death qualified, both those who would automatically impose death and those who would automatically impose life. And there's a lot of research, this is an issue which will be explored down the line, but there's a lot of research which shows that that process skews the panel as unrepresentative. It excludes people who are knowledgeable because they read this media coverage. It excludes, the evidence shows, minority groups, women, and people that normally would be included in a representative jury. So yeah, you can void your jury on whether they've heard the President of the United States say that Mr. Robinson should be executed, and you can exclude that juror from serving on this case. But given the demographics of this county, you're going to be excluding a large portion of the population. And then when you add to that the death qualification process, you no longer end up with a representative jury. You end up with what the U.S. Supreme Court in Witherspoon versus Illinois called a group organized to return a death verdict. But it's not a representative jury. So as Chief Justice Rehnquist said in his opinion, even if you employ these other means, they come with a great cost, and in this case, a great constitutional cost. So those are the main points I wanted to make to the court, and I hope I haven't repeated things that the court is already familiar with, but I'm certainly happy to answer any questions the court may have.
Well, what I think I'm going to do is wait till the state makes their argument, and then I'll have questions. That's going to put the picture together for me, and then have questions for all parties. I just want to make sure I hear it all, and I appreciate your arguments, Mr.
Makes
Burton.
sense. Thank you, Your Honor.
All right. Turning to the state.
Your Honor, Christopher Ballard on behalf of the state. First of all, let me just set the table for the court, because I think there's a motion pending that defendant didn't mention, and that's the motion to classify the reply brief in support of their motion to exclude cameras. Would Your Honor like that docket number?
Yes.
That motion is docket number 400. So as I understand it today, we've got 4 motions in front of the court, 3 of them dealing with classifying documents that have been filed. First is the January 9th motion. Then we've got a motion to classify the motion to exclude cameras, which Mr. Burt has just addressed. A motion to classify the reply in support of that motion to exclude cameras, which I just mentioned is docket number 400. And then also a motion to close portions of the hearing in April that Mr. Burt has also addressed. So it's my understanding that we're here on those 4 motions. Would it be helpful for the court for me to give you the state's opposition to those motions, the docket numbers for those?
That would be helpful, Mr. Ballard. Thank you.
Sure. So on the January 9th motion, state's opposition is docket 340. On defendant's motion to classify the motion to exclude cameras, the state's opposition is docket number 346. On the defendant's motion to classify the reply supporting its motion to exclude cameras, the state's opposition is docket number 431. And then on the motion to close portions of the April hearing, the state's opposition is docket number 448.
Thank you.
I think part of the problem with this is on 3 of these motions, we don't have any requests to submit. There is a request to submit that the media helpfully filed on the January 9th motion, and that lists all of the docket numbers of the relevant documents. There's been quite a few on that one. So hopefully that's helpful for the court.
Yes.
Okay, the next thing I want to clarify is the standards that apply to these 2 different categories of motions. The defense here has not been very careful about articulating and applying the correct legal standards that govern these motions, because there are different standards that apply to classifying documents as opposed to closing a hearing. The standard that applies to classifying documents is found in the Utah Rules of Judicial Administration. That's Rule 4-202, let's see, 0.04. But the standard that applies to closing a hearing, as the state explained in its opposition, is governed by case law, and that's the Kearns Tribune case and subsequent cases following that case. And then I also want to just clarify that Rule 3.6 of the Rules of Professional Conduct that's also been mentioned, that rule, while it might be relevant because it talks about pretrial publicity, it does not govern any of these motions. Because Rule 3.6 talks about lawyers making extrajudicial statements. We're not concerned about any extrajudicial statements in any of these motions or in closing the hearing. Obviously, everything that's going to occur in the hearing is going to occur in court. And I also just want to emphasize that Rule 3.6 makes it clear that there's nothing improper about a lawyer commenting on information that's contained in a public record like the information that's filed in a criminal case. Now, with respect to the first motion to classify defendant's January 9th motion that has to do with the evidence, the state did mention Rule 3.6 when it submitted its notice of intent to test evidence. The state did that because the state recognizes that under Rule 3.6 there can be concerns about statements that deal with evidence and testing and results of tests. Our hope, and I guess it's proved to be overly optimistic, was that if we could do this without having to file something in court, we could get this issue resolved of whether we could go forward with the testing. We'd get that resolved. We wouldn't need to be here in a hearing like this today arguing about whether something needs to be public or private. We could hopefully move forward, get the testing done, and get us that much closer to trial. The state was not suggesting that there would be anything improper about filing a motion and having this type of evidence listed in a public document. So that was not the state's intent in originally mentioning Rule 3.6. We were just recognizing that there could be concerns, and hopefully in hopes of avoiding any kind of hearing like this and getting this issue resolved as far as the testing goes, that we could move forward. But we find ourselves here. Now, another thing I want to clarify is we are not media lawyers. We are not representing the interests of the media. Our client is the people of the state of Utah, who do have an interest in the public nature of these proceedings. But whether any particular document in this case is public or private is really of secondary concern to the state here. We're not trying to represent any kind of media interest, and I think it's improper for the defense to suggest that. Although maybe the media might want to hire us because we probably charge much lower rates than the media's lawyers. But we're not representing the media's interests. We are just, our primary concern is moving this case forward and applying the correct standards in the law. So with that, let me turn to the substance of our response to the motion to classify the January 9th motion. It's clear from the rules of judicial administration that that document, having been filed with the court, is a presumptively public document. And a general allegation that it discusses evidence that might be inadmissible is not enough to deny public access. If that were enough, then any motion that discussed evidence before there was a ruling on the admissibility of that evidence would have to be private. And even if there were some basis for ultimately finding that the evidence discussed in the motion was inadmissible. Public exposure to that kind of evidence does not necessarily justify, or it does not necessarily prejudice defendant's right to a fair trial and justify sealing that document. And the controlling case of State versus Allgaier here from the Utah Supreme Court in 2011 is very instructive on this point. It's instructive to all of these motions. Allgaier was a capital case. And the issue in Allgaier concerned a letter that was sent to the court from a fellow inmate of Curtis Allgaier, the defendant in that case, who'd been charged with capital murder. And the letter stated that the defendant had confessed to aggravated murder and also threatened the inmate and the inmate's mother if the inmate revealed that confession. I can't imagine any more potentially prejudicial information in a capital case. It's a clear admission of guilt. It's a clear admission of future dangerousness. So the defendant in that case obviously wanted to keep that letter private. But the court denied that request because that information that was in the letter was already contained in the public record. Now that fact is not necessarily relevant to this motion to classify the January 9th filing, but it is relevant to the rest of the motions here. But what the court said next in affirming the trial court's decision in Allgaier to release that letter is really instructive, because the court recognized that despite already circulating reports of highly prejudicial information, there were alternatives to restricting public access to the document. And those reasonable alternatives are the time-honored tools of jury selection. That's how we screen out jurors whose prior knowledge renders them unable to objectively view the evidence. And I think it's interesting in Allgaier that the court said those tools would be effective to protect the defendant's right to a fair trial, regardless of whether how that balancing came out, whether the court said, yes, this is so prejudicial, it shouldn't be released, or the risk of prejudice is not high enough to justify restricting access. That ruling, that holding in Allgaier coincides perfectly with the United States Supreme Court's analysis in the case of Press Enterprise 2, where they mentioned as well that through voir dire, a court can identify those jurors whose prior knowledge of the case would disable them from rendering an impartial verdict. And as far as this notion of the court can't expand the jury pool, that's certainly not the case. The court can summon as many Utah County jurors as it deems necessary to be able to seat a fair and impartial jury. What happened in the Richens case is that given that Summit County is a smaller population county, they tried to expand the Summit County jury pool with jurors from Salt Lake County. And there's nothing that allows you to take jurors from a different jurisdiction and add them to the jury pool. But we're here in the second largest county in the state. There's not going to be any problem with expanding the jury pool here. I'll just briefly touch on, as far as the other two motions, to classify the motion to exclude cameras and the reply in support of that motion. I think basically the same arguments apply. The only thing I would add there too is that this idea of where there's so much media coverage that you've got to necessarily find that there's some prejudice. I don't know that it necessarily works that way. I think that the fact that media coverage becomes so pervasive can also tend to dilute the effects of that media coverage, because when something becomes a constant drone, a lot of people tend to tune it out. Now, for sure, there'll be people that are fixated on this case, but we weed those out through careful questioning during voir dire. And I also point out that not all media reports in this case have been unfavorable to the defendant and favorable to the state. It's gone both ways here. There's media that the state's concerned about as well. So just saying that this is a content tornado or there's been a barrage of media coverage doesn't necessarily mean that there is going to be prejudice to the defendant. I'll turn then finally to the motion to close portions of the hearing. And again, there's a different standard that governs that motion. It's not governed by the rules of judicial administration. To close a court hearing, a court has to look at the specific nature of the proceeding at issue and determine, first of all, whether there's a presumptive right to public access to that type of proceeding. Now, defendants waived any argument that there's no presumptive right of public access because he hasn't argued otherwise. Instead, he's assumed that there is a right to public access and has argued for the court to close that hearing. But again, defendant has incorrectly relied on the standards that govern classifying documents rather than the standards that govern closing a court proceeding. But the same arguments still basically apply, that the defendant would have to show that the closure is necessary to protect his right to a fair trial, and we don't believe that he could make that showing where most of the documents or most of the evidence that's going to be discussed at that hearing is already public, and that's where that other portion of the Allgaier case comes in. If you're going to be discussing things that are already public, that tends to favor keeping the proceeding public rather than closing it. Now, the state does agree with the defendant on 2 points in that motion. To the extent that the hearing is going to discuss media coverage that has violated the court's decorum orders, we would agree that those portions of that hearing should be closed because that would be just committing further violations of the court's decorum orders by repeating that evidence. And then defendant has also mentioned that there are personal privacy concerns to some people and that they want to discuss media reports that have created concerns about personal privacy and safety, and the state would agree that those concerns are sufficient to justify closing the hearing. So we would agree with the defendant that portions of the hearing that discuss decorum order violations and that implicate personal privacy and safety, those should be closed, but otherwise that April 17th hearing should be open, especially where it's just going to be talking about things that are already public. Right. Does Your Honor have any other questions?
Not just yet. Thank you, Mr. Ballard.
Thank you.
Any other argument?
Yes, Your Honor.
Thank you. And counsel, remind me your name.
And for Your Honor's benefit, I intend to handle the argument on the motions to classify, and Mr. Jed intends to handle the argument on the motion to close the April 17th hearing.
Thank you.
So I'll start with the motion to classify the January 9th, 2026 motion. That's docket 285. And for the court's benefit, the news media oppositions are at docket 302, docket 337. And then we also filed a supplemental opposition on March 10th. I don't believe that has been filed on the docket yet because we filed it under seal and there wasn't a way for us as non-parties to file it on the docket. I will note that I do think the court granted our motion to file under seal, but it looks like the motion that was sealed, the opposition that was sealed was, I think, the incorrect opposition. I think the sealed one was docket 451, and that should have been kept public, whereas the one we sent to the court via email is the one that should be sealed privately.
Thank you for that clarification.
Yes, and we can clarify it again later if that's helpful. So starting with the motion to classify the January 9th, 2026 motion. And before I get into our arguments, I'll just clarify that I don't intend to comment on sort of the substantive arguments in the motion or the underlying evidence referred to. So as the state argued, filings are presumptively public. That's in the rule, it's clear as day. I do want to differ from the state a little bit though. So Rule 4-20202 sort of explains what the court needs to do when it's deciding whether or not to keep a filing public or to allow it to be sealed. What that rule doesn't exactly do is tell the court what sort of is the standard that it's applying when it's weighing the interests. And for that standard, I would refer the court to Press Enterprise 2. That's 478 U.S. 1. And I know Mr. Judd intends to talk about this a little as well, so I won't go into too much detail. But that's the case from the U.S. Supreme Court that was decided after Kearns Tribune, which the parties already referred to. And in that case, the court said that when a court is deciding to close a proceeding, so it wasn't referring to filings or documents specifically, but it was talking about a proceeding like a preliminary hearing. It said the court has to make specific findings, and there has to be a substantial probability that fair trial rights will be prejudiced. And the court was very clear that the standard is substantial probability. And then the court also said there has to be no less restrictive alternatives. So that really maps nicely onto Rule 4-20202. The only difference being that in Press Enterprise, the court clarified the standard is substantial probability of prejudice. And although that case was referring to hearings, open hearings and open court filings are just two sides of the same coin. They're stemming from the First Amendment, they protect the same interests. So there really is no need for the court to consider or apply a different standard for open filings or open proceedings. It can really be that Press Enterprise 2 test. But really, whether you're looking only at Rule 4-20202 or whether you're looking at Press Enterprise 2, the outcome for this motion in particular is the same. And that's because, as Mr. Ballard referenced, filings are presumptively public, and that doesn't change just because the court hasn't ruled on the admissibility of the evidence. You can look at, for that standard, you can look for cases like State v. Archuleta, that's 857 P. 2nd 234, that's the Utah Supreme Court. Also the Algier case, 2011, UT 47. There, the defendant made the argument the letter would have been inadmissible, and the court still said it should have been made public. And then also even United States versus McVeigh, which is a case cited by the defense, and that's 119 F. 3rd 806, and that's a 10th Circuit case. And then I finally, just the final point I want to make on this motion is the arguments from the defense about why this motion needs to be kept sealed are really quite generic arguments about pre-trial evidence. They could have been applied in any type of case to any type of evidence. And I understand that the defense is being careful because we're in a public setting. I understand and appreciate that. But the arguments in their sealed filings were just as generic and just as applicable to any type of pre-trial evidence. And as we argue in our supplemental opposition, we don't think the actual arguments made in the motion justify that this type of evidence needs to be kept private. So unless Your Honor has any questions about that motion to classify, I'll move on to the next two.
Yes, go ahead.
So the next two motions to classify are relating to the motion to exclude cameras, and that is dockets 310, that's the motion to classify the primary motion, and then docket 400, which is the motion to classify the reply in support of the motion to exclude. And the news media oppositions can be found at docket 323 and docket 429. So for these motions in particular and the reply, I just want to make very clear that you cannot make public information private by putting it in a court filing. That's because filings are presumptively public, but also because, again, the information is public. You can't take a public thing, put it in a public forum, and it suddenly ends up being private. That just is not how the rule works. There has to be some sort of showing as to why this information can't be made public, but again, it already is public, including, in fact, information that was created by the public. So if the motion to exclude is kept private, what that's saying to the public is you can't have access to information that you in fact created. Similarly, the court cannot prohibit the public from discussing information that is already public. That is a prior restraint on speech. If there is news articles, if there are comments from public officials, the news has a right to report on that. The court cannot control that. So making this motion and this reply private or sealed, that's just not something that can actually control the speech. So this attempt to sort of control the public discourse, it's just ineffective, and it's also unconstitutional because it is a prior restraint on what can be reported on. The defense's argument there is that they shouldn't have to republish the information, but nobody is asking them to republish the information. They have decided to assert these arguments in the motion. They have decided to include all of this evidence. That was their decision, and they put it on the court docket. So the presumption is that it is public. And the news media, in our opposition to that motion, not the motion to classify, but the motion to exclude cameras, one of the points we made is that a lot of this stuff doesn't even deal with electronic media coverage. It's referring to statements made by public officials before the proceedings even began. So the defense's position that they had to include these things, we would push back against, because we don't think a lot of the things cited are even relevant to the actually narrow question that is before the court about whether electronic media coverage should continue. Because some of those statements aren't even really connected to electronic media coverage. They're connected to things that public officials said or did before the proceedings began. And we don't have a dog in that fight. We're not trying to litigate whether or not that was lawful or not. We're just trying to litigate, should electronic media coverage continue? And so the defense really didn't need to include, we argue, a lot of the things they did include, that again are public statements that the public has a right to see and have access to, and in fact already has access to. So there is no reason to exclude the public from seeing those things. And for that argument in particular, I would again refer the court to Al Geyer, where the court talked about that very specific point, saying if the information is already in the public, then there's not anything the court can do by trying to restrict that information. Again, the best tools available to the court are the time-honored things that the court can control. The court cannot control public discourse, but it can control the jury that is actually seated and ensure that that is a fair and impartial jury. And so that is the best method. Are there any questions Your Honor had on that motion?
No, thank you.
Yep, and before I sit down, I also wanted to add, I am prepared to address standing. I didn't know if that was something you wanted to hear from the news media today, but I am prepared to address that if you would like.
Right now, no. Thank you. Mr. Judd.
Thank you. Thank you, Your Honor. As Ms. Uresk suggested, I'm going to address briefly the motion to close the April 17th hearing in part. The docket numbers for the briefing on that are docket number 425, that's the defense's opening motion. Docket 448, that's the state's response. And docket 451, that's the media's opposition. Ms. Visser at the outset said something that I'm sympathetic with. I know the court has a lot of briefing before it on these motions, and she mentioned that it felt like we were drowning in a First Amendment briefing. I don't think anyone wants to drown, but if I had to drown in something, I think I would drown in First Amendment briefing. Sounds delightful. The court ultimately needs to make a practical decision about each of these motions in front of it, and that's a tough task, and I want to help the court with that the best that I can. If the court is going to close or seal anything, the court has to make findings, and the court has to explain which interests it's weighing. It also has to do an important thing in determining that the restriction it's imposing on public access is the narrowest possible way of protecting the countervailing interests in favor of secrecy. So that's tough. The court's been through that several times already, including with the motion to disqualify and the hearing there. How do we identify an interest that we may believe justifies an exception from this rule that the public gets access to these proceedings? And then how do I make that as narrow as possible to ensure that if that interest needs to be protected, I am, but it's narrow. I'm grateful, therefore, that the defense got this motion on file in time for us to discuss it today, so that we can talk about that April 17th hearing today in advance. And I'm also grateful that that motion and both oppositions recognize what I think has to be the case, which is most of that hearing, if not all of it, needs to be open. The two sides have talked about the kinds of hearings that are presumptively open. This is one of those. There's no reason that it shouldn't be. It's not a juvenile matter. It's not another type of sensitive matter that would qualify, and any argument to the contrary has been waived. So we start with the presumption that this is open. The defense also recognizes, I think, that most of it should be anyway, that the things that they seek to protect are some narrow categories of information. I think where we run into challenges is a lack of specificity. And if we can't get to the specifics, justifying what exactly would need to be closed and why, then the presumption wins and it stays open. I see in the motion an argument that something about what they call a litany of potentially prejudicial statements may not want to be introduced. But of course, for the court to enter a ruling saying, okay, that part of the hearing will be closed, we have nowhere near the kind of specificity we would need to say what that would even look like. Would there be some sort of short colloquy where certain pieces of evidence would be introduced? If so, what? A certain statement by a public official? A certain news clip? A certain statement? We don't know. Because the motion that will be discussed at the April 17th hearing is 185 pages long, and it has, again, a litany of information. It's possible that there may be some part of some piece of evidence in that weighty motion that the court may be better to review in camera, right? So as to not publicize it again and risk this republication problem. But we don't know what that is at this point. Another suggestion is that the December 11th closed portion may be discussed there. I think that's gone. I think we now have a transcript that has almost all of that hearing open. The last piece is that there may be some kind of private and personal information. Sorry, there's two more. There may be some sort of private personal information, potentially for a witness. The court has, very narrowly in the past, in this case, identified one instance where keeping at least one bit of identifying information off camera may be appropriate. Maybe the court would see fit to do so again here, but we don't know what the ask is. And at this point saying, okay, I will grant the motion to close a portion of that hearing to the extent that it implicates some kind of private information would be impossible for the court to do, because the court can't do that balancing test that the rule requires without that type of clarity. The last piece is alleged violations of the decorum order. Again, I struggle a little bit to understand exactly what would be presented that would justify closure. I think discussing, hey, we believe in these cases and these types of media coverage, there was something that was a violation. Something was shown that shouldn't have been, and here's the problem that it creates. Again, if we want to show the media clip in which that decorum order violation was broadcast, I think that wouldn't justify or necessitate closing the hearing. The court could look at it on its screen. The defense could refer to what we're going to show you right now is the following kind of violation. In short, I think the task that's been put in front of the court to attempt to close part of that hearing right now is impossible. What would the court say, I am going to close at this point, when everybody decides that the vast majority of that hearing needs to be open? It may be possible when we get to that April 17th hearing that the court may be faced with a request to say, here's what we're going to present. We're going to put this witness up, and this witness is going to talk about this thing. And it may have a more complete ability to rule on that specific issue then. But as of right now, I think not only should most of that hearing stay open, which everyone has agreed to here, but in the media's view, everything should. The last thing that I want to mention is the unique feature, the unique nature of this hearing. There's all kinds of different hearings, and they may, preliminary hearings, evidentiary hearings, the trial itself, those all may have different standards. What's unique about this hearing, of course, is that this motion asks the court to turn off cameras, to mute the microphones, and to no longer let the public be the kind of participant in this hearing that it has, in this proceeding that it has been to date. Saying, not only should the cameras be turned off, not only should the microphones be turned off, but the argument as to why that should happen should be sealed from the public, and the public kept out of that hearing strikes me as the exact opposite of what the presumption of public access is meant to do. Of all the types of things that the public should be able to see argued, a question as to whether or not the public will be able to continue to observe the proceedings in the case seems like close to the highest potential instance in which public access should be granted in that case. we think this hearing should be open. The parties are taking all the measures that they can, and I know we have hard work from our people here representing the media and the public to try to abide by the court's decorum order. The court has done heavy lifting so far to initiate and refine that decorum order to balance the interests. We believe that that is the approach the court should continue to take, to continue to allow access, but to have appropriate restrictions to balance the interests. And we ask the court to do that with respect to the April 17th hearing as well.
Thank you, Mr. Chad. Defense, do you want to have a response?
Responding first to Mr. Ballard's arguments, Your Honor, quote, we are not concerned with extrajudicial statements. That is not correct. The motion, and also responding to Mr. Judd's argument that we're not specific as to what it is we don't want publicized, that the motion sets forth 305 in great detail, the specific prejudicial pretrial publicity that we think prejudices Mr. Robinson's right to a fair trial. So it's hard to understand in light of the length of that motion and the detail at which the prejudicial publicity is set forth, how a media lawyer can stand before you and make a statement that we have no idea what they're asking to be excluded. What we're concerned about, as I indicated in the argument, is the specific categories of prejudicial information outlined in 305 that state opinions, extrajudicial opinions of public officials, extrajudicial opinions of the prosecutors, of law enforcement authorities. So when Mr. Ballard said we aren't concerned with extrajudicial statements, we are concerned with that. And those extrajudicial statements are outlined in the motion itself very specifically, so the court has in front of it. And if the court, if it would assist the court, we could proffer to the court a proposed redacted motion which would take out everything identified in that motion as prejudicial pretrial publicity. I think it's obvious from the face of the motion what that information is, but if it would assist the media in understanding exactly what we're talking about, we're more than happy to do that, and if that would assist the court. The idea that one of the media lawyers said, oh, the statements of the of public officials are not connected with the media. I can't understand, for the life of me, understand what that means. The media publicizes those statements, and if the court looks at all of the linked electronic media coverage that we've got outlined in the motion, the court will see it's a very slanted, biased rendition of the prosecution's version that Mr. Robinson is guilty and should be sentenced to death. There's no impartial reporting in any of the electronic media. So when the media lawyer says, this coverage is, they're just public officials, we have no control over them, we're not in any way responsible for what they say or what they don't say, that is false. They are responsible in the sense that they are putting in front of the public a distorted view of an incriminating portrayal of Mr. Robinson. And that theme of incrimination is repeated over and over in virtually every one of the clips that we provided to the court. And we've emphasized that those clips are merely the tip of the iceberg. And we will present during the hearing much more than what's presented in the motion to prove that very point. And so there is a connection. And it's not only the electronic media, but the social media who is taking this information and spinning these theories of incrimination. Mr. Ballard says, oh, well, it's not, we haven't told the whole picture because some of that is pro-defense, and he indicates in his pleading that they're going to put in at the hearing publicity concerning conspiracy theories that are out there. And the implication is that those conspiracy theories somehow help Mr. Robinson. But we're on the side here of using this trial as a method to find truth. We have no interest in advocating conspiracy theories, whether they help Mr. Robinson or not. So I think it'd be helpful for the court to see some of these conspiracy theories. But the main point is the public is not being educated by electronic media. They're being biased by it, and they're being slanted to extreme views on both ends of the spectrum. And that's where the court, under the Maxwell case, says the trial court has a primary responsibility to step in and take measures that could lessen the impact of that publicity. The idea that it's already out there, and the Algiers case, I want to focus for a minute on that case, because I think, if anything, it supports the argument we're making. The court in that case was concerned with a letter from a jailhouse informant, a single letter, who claimed that Mr. Algiers, I'm sure I'm mispronouncing his name, had confessed to him in a jailhouse conversation. And the trial court refused to seal the letter because there was already other publicity. We don't know what that other publicity is. It's not detailed in the Utah Supreme Court's opinion. But when the case reached the Utah Supreme Court, critical fact for the Supreme Court, was that in the briefing in front of the Supreme Court, Mr. Algiers had included the letter that had been sealed by the trial court pending the appeal. He himself disclosed the content of that letter. And the Utah Supreme Court said, in affirming the decision of the district court that the interest favoring unsealing the letter outweigh the interest that favor keeping it sealed, we note that since the time of the district court's decision, most of the significant information contained in the letter had been introduced into the public arena. Specifically, in his brief in this court, which is a public document, Mr. Algiers included the third district court's decision to unseal the letter. That decision, which was filed under seal, quoted the letter. Because these portions of the letter have been placed by Mr. Algiers into the public arena and are therefore accessible to the media, any significant interests that would be protected by requiring the letter to remain sealed are now greatly diminished. So how does that case compare to this one? Well, first of all, we're not dealing with information that the defense has voluntarily put into the public domain. In Algiers, there was no motion to file the letter under seal by Mr. Algiers. In this case, we filed all the relevant pleadings here with a request that they be classified as private. So counsel for the media misspeaks when they say, oh, well, once it's filed, it's in the public domain. The very purpose of the procedure to make something private is for the court to rule on whether it should be considered a public filing. So that procedure was followed here. It was not followed in Algiers. He put the documents into the public domain. The second thing is, I think, strains credibility to say that the factual record in Algiers is in any way comparable to the extent and nature of pretrial publicity in this case. We're not dealing with a confession letter by a jailhouse informant, a single letter by a jailhouse informant. You can't compare the President of the United States, the Vice President, the Governor, to a jailhouse informant in terms of the weight that the public is likely to give to that information. So the court in Algiers was not saying, we don't care what the pretrial publicity is. We're holding that in every case where there's been any disclosure of information, no matter what it is, that's the end of the ballgame, and the court has no obligation to try and restrict further prejudicial pretrial information. The court never said that. And when Mr. Ballard says he can't imagine any more prejudicial information than a letter from a jailhouse informant, I would recommend to him the facts of this case, because this is a case that goes way beyond a single letter from a jailhouse informant. It covers opinions by highly respected, in this county anyway, public officials who directly state that Mr. Robinson is guilty and deserves the death penalty. And Mr. Ballard says Rule 3.6 has no relevance here. It has relevance to the extent that it defines what prejudicial pretrial publicity is. It defines what the categories are. And the Levitt decision, which is cited in our motion by the recent decision by the Utah Supreme Court, emphasizes that the categories outlined in the commentary of Section 3.6 identify what those categories of prejudicial pretrial publicity are. And it's not, again, unlike Algiers, we're not talking about a single instance. We're talking about repeated exposure to the most prejudicial information that is imaginable. And what will come out of today's hearing will be more of the same. In other words, right now, as we're talking, there are media talking heads, law school professors, criminal defense lawyers who are being paid for their opinions and not disclosing that they're being paid for their opinions, who will say things like, oh, this motion by the defense is absolutely frivolous, or this motion is wrong, or this is why this motion should be denied by the court, or characterizing Mr. Robinson's demeanor, etc. So this case is not comparable in any way to Algiers, and the court should not buy into the notion that they are comparable. The idea that we're mixing the standards, I think, could be bounced back to their side, because they say, oh, the standard for closure of a hearing is compelling state interest and no reasonable alternatives. But they skip a step, which is this type of a hearing that we're seeking to close, the portions of which will discuss the prejudicial pretrial publicity. Is that subject to a First Amendment right of access? We haven't waived that argument. That's an argument that Kern says should be at the forefront of the court's analysis, regardless of which side is raising the issue. The court has to determine whether this hearing on the 17th is comparable to a trial or to a prelim. It's unique in the sense that it's focused solely on what everybody has to say is inadmissible evidence. Is that the type of procedure that there should be a compelling interest demonstrated? And in any event, we have demonstrated a compelling interest. Mr. Robinson's right to a fair trial by an impartial and representative jury. And that right, according to the U.S. Supreme Court, takes precedence over every other right. The press enterprise case that was cited about the efficacy of voir dire and the Algiers case that was cited for the same proposition conflicts with Gentile versus Board of the State Bar, which was decided years after Press Enterprise 2. Press Enterprise 2 is decided in 86. Gentile's decided in 91. And if you look in the discussion in Algiers about what cases are cited when the court talks about the efficacy of voir dire, Gentile is nowhere mentioned. So the Supreme Court may have its own view, the Utah Supreme Court may have its own views about the efficacy of voir dire, but I would ask, how does one explore with a juror whether they have been exposed to publicity that is specifically prejudicial, things like a confession? Do you bring, well, did you see any, have you read, you ask a juror, have you read or seen anything in the electronic media about this case? Not that I recall, is a typical answer, even if they've seen a lot. And then the next question was, when you attempt, can you, or should you attempt to jog their memory by mentioning specific prejudicial information? Well, how about a confession? How about a statement by the President of the United States that Mr. Robinson should be executed? Have you seen anything like that? Now, that type of voir dire is designed to bring to the jury's attention the very information you don't want them to have. So, just throwing out the vague proposition that, oh, voir dire, the traditional means of curing pretrial prejudice, doesn't deal with the realities of voir dire in a capital case where the prejudicial publicity is as extensive as this one. There is a discussion of this issue in an older case, but it always struck me as kind of really stating the truth of it. In the court, this is an old high publicity murder case, California case, Corona versus Superior Court, 24 Calap 3rd, 872. And the court is characterizing its experience with voir dire as an effective method. And the court says, questioning on voir dire as to the effect of the media's evidentiary disclosures, one prospective juror may deny or admit awareness, another disclaim or admit prejudgment. One may falsely deny both knowledge and prejudice for the sake of a place on the jury. An honest juror may admit knowledge or tentative prejudgment and find himself excluded. Many will sincerely try to set aside their preconceptions and give assurances of impartiality, yet unconsciously bend to the influence of initial impressions gained from the news media. And along the same lines, we have in this case an expert declaration that is discussed in docket 305, which talks about the importance of repetition in causing conscious and unconscious bias in jurors. And the importance of unconscious bias is it's by definition bias that cannot be weeded out by voir dire because the juror doesn't know they've been affected by it. And the expert, this is page 94 of 305, says the volume of coverage in notorious cases can be overwhelming. And studies show that the quantity of pretrial publicity to which jurors are exposed affects their level of bias. Across studies extending back several decades, researchers have demonstrated that individuals exhibit a greater propensity to prejudge defendants when they are exposed to more publicity, both as a general conclusion, i.e. showing a general propensity to prejudgment based on an increase in the amount of exposure, and in response to specific thresholds, i.e. showing that prospective jurors exposed to at least 3 newspaper articles about a crime were more likely to believe there was ample evidence against the defendant. This effect has been demonstrated in both naturally occurring and controlled settings, confirming the validity of the proposition. And along the same lines, the U.S. Supreme Court, in a case cited on that same page, U.S. Department of Justice versus Reporters Committee for Freedom of the Press, 489 U.S. 749, says, the fact that an event is not wholly private does not mean that an individual has no interest in limiting disclosure or dissemination of that information. So the fact that there's already existing prejudicial pretrial publicity out there should not give rise to the conclusion that, oh, well, let's add some more. Because the court at this stage of the process still has the ability to control this process in a way that will protect Mr. Robinson's right to a fair and impartial jury by a representative jury. And just to say, well, we'll handle it down the road is to ignore the mandate of Maxwell that the court has to be proactive and to take action before the prejudice happens. So we're seeking to prevent future prejudice. It's already existing, there's no doubt about that. But to throw your hands up at this point, this early stage of the case, and say there's nothing I can do about it, we're just going to continue along the same lines, allow these people to keep making these prejudicial statements, and hope for the best down the line, and that we won't have to exhaust the entire pool, we won't have to move for a change of venue. And again, there are costs associated with those remedies that we think argues in favor of this motion.
Thank you, Mr. Burt.
Thank you.
All right, I just have couple of questions for the parties. The intent is to obtain these, and then the court will take a brief recess. I want to discuss, issue its ruling, and I want to update my notes. I've been taking notes the whole time. I'll be issuing a ruling, but I also, based off that ruling, will want to talk about what the expectation for the next hearing is, to set the guidelines in place so we all come in prepared, knowing what the expectation is and what we'll be handling specifically. All right, to the defense, most pretrial motions discuss evidence that has not yet been ruled admissible. If the court seals a January 9th motion simply because the evidence might be deemed inadmissible later, wouldn't that set a precedent requiring the court to seal almost all pretrial evidentiary filings?
I think it would depend on the nature of the evidence. In other words, if it's evidence that doesn't go to the heart of the case, the court always has to consider the nature of the evidence. Right. Here we're talking about essential forensic testing opinion evidence. And so that puts it into a category that I think is distinct from any and all motions having to do with any sort of evidence. There may be some evidence that doesn't fall into that category. And I note that on the precise issue the court raises, the sentence in Kern's tribute addresses that. The court says, if the prosecution elected to try to use such evidence in the preliminary hearing, in advance of a ruling on whether it should be suppressed, the defendant could seek special measures to avoid its public disclosure. So I read that as saying the court is not really focused on whether there has been a ruling on admissibility. It's, again, what is the nature of the evidence? Why are you trying to disclose it? And I think the court can make reasonable distinctions between, is this the kind of evidence that could cause problems, or is it, in the harmless error category?
Thank you, Mr. Burt.
Sure.
And in offering the opportunity, do the other parties wish to respond to that question? You don't have to, but if you want to, I certainly want to give you that opportunity.
No, Your Honor, thank you.
All right.
I'll just respond to Your Honor.
All right.
Carissa Urask on behalf of the news media again. So just to respond to the argument that the test should be whether the evidence goes to the heart of the case, that's not really a standard that I'm aware of in case law or the rules. Again, the court goes through the balancing test, and there has to be, specific findings. There could be a substantial probability of prejudice. And here I would just argue that's just not the case. And I will just direct the court to the arguments we made in our sealed supplemental opposition that is very specific to this motion as to why that showing has not been made here.
Thank you. All right, to defense, you noted if full classification is denied, you would seek to file redacted versions. Have you prepared a proposed redacted version of these motions, and do you believe redacting the specific evidentiary exhibits and media links would sufficiently cure your constitutional concerns?
We haven't yet prepared those redactions, but it's easily done because it focuses on the factual portion of the motion. So essentially it would be submitted to the court the legal arguments absent the factual basis that's discussed in the statement of facts and later referenced in regard to the criteria under the rule, some of the publicity set forth there as well. So it can be easily done. It would satisfy the concern insofar as the motion goes. What you would lose in that, I think, is at the hearing itself, having the court have the ability to actually listen to the evidence. I'm not sure. I think that falls into a different category. In other words, the motion is one thing, but presenting it live to the court, I think presents a different issue. And perhaps that can be addressed by submitting to the court in camera the clips that are outlined in the motion, which that would satisfy our concern. But the only other thing I think could arise is if experts are commenting on something the court has considered in camera, those opinions might disclose that information. So that could be a special problem. But in general, I think redacting the motions and providing the court with a disk or a thumb drive that contained the clips with the understanding that that would not be disclosed. In other words, by providing that to the court, the media would say, oh, you provided it to the court, therefore it's filed and we're entitled to it. I think the understanding would have to be the court is being provided this with the understanding it is private. And to answer the court's question, I think those kind of remedies would resolve the issue.
Thank you, Mr. Birch.
Sure.
All right, turning to the state, the defendant argues that publicly filing the motion to exclude forces them to republish prejudicial media links and private information protected by grandma, effectively doing the media's work for them. Does the state acknowledge any risk to the integrity of the proceedings by hosting a consolidated repository of this potential prejudicial material on the public docket?
I think, defendant, you can't ignore the fact that there is a risk that when you repeat something, it's emphasized. Certainly we agree with that there's a risk of that. I think Allgaier is controlling, though, where it says the fact that something is already public tends to support that should remain public, and that Allgaier, it didn't directly address whether that would risk republication, whether the republication would risk emphasizing, but certainly that's the undertone there in Allgaier. And I just wanted to clarify one point there. If you look at paragraph, just let me grab my computer.
Sure.
If you look at paragraph 16 of Allgaier, this is about the point that Mr. Burt made that defense counsel in Allgaier actually attached the letter to his public brief in the Supreme Court. That was not the decisive factor in Allgaier. All that did was give the court even greater confidence that affirming the district court's ruling to release the letter was correct. If you look at paragraph 16 in Allgaier, about halfway through the paragraph, it says, the district court considered the specific language within the Cobb letter. Cobb is the name of the inmate. The specific language within the Cobb letter and its potential impact on Mr. Allgaier's right to a fair trial. But the district court concluded that given the amount and type of prejudicial information already in the public domain at the time of its decision, unsealing the Cobb letter would not undermine Mr. Allgaier's right to a fair trial. So the district court's decision was based on what was already in the public, the information that was already public when the letter came before the court. The letter at that time was still sealed. And then the Supreme Court does not say, it doesn't question whether that balancing was correct or not. It says we are, in affirming the decision of the district court, we note that the letter there's even more information of the same kind that was already contained in the letter because the letter itself was now attached to the brief. So the decision in Allgaier was based on the information that was already in the public domain, even absent the defendant attaching the letter to his brief.
All right, thank you. Court has no further questions. We are right at the noon hour. the court intends to take a 15-minute recess to review my notes, considering the arguments, and to issue a ruling on this case as it relates to what's before the court. And then we'll come back and discuss how we will address the April 17th hearing. Court is in a brief recess.
All right.
Thank you for the patience of the parties. This court has considered the oral arguments made today and has considered the briefing which has been previously submitted. And I commend the parties for their diligence, their arguments, as well as the quality of briefing that was done on this issue. And so the court is going to issue its ruling on what is requested and what is before the court. Before the court are 3 motions to classify court records. Defendant's motion to classify as private motion filed January 9th with exhibits. Defendant's, and which is docket 285. Defendant's motion to classify motion to exclude, docket 310. And defendant's motion to classify reply in support of motion to exclude, docket 400. The public has a presumptive right to access court records. Open court records assist in educating the public about the workings of government and the decisions being made on the public's behalf. Contribute to the informed debate, allow the public to hold public officers and employees accountable, increase public confidence, and provide material for independent research on improving government policy. The right of access, however, is not absolute, as cited to in Algier. Other factors may favor closure of the records, such as protecting personal privacy, non-parties participating in the court proceedings, and a defendant's right to a fair trial. A court may consider any relevant factor, interest, or policy in favor of and opposition to closure in determining whether to classify or close all or part of a court record. In making its determination, a court must make findings and conclusions about specific court records, identify and balance the interests favoring opening and closing the record, and, if the record is ordered closed, determine that there are no reasonable alternatives to closure sufficient to protect the interests favoring closure. With this legal framework in mind, the court now turns to the pending motions to classify. And as it relates to defendant's motion to classify as private motion filed January 9th with exhibits docket 285. Defendant seeks to classify a motion filed on January 9th, 2026 as private because it addresses evidence that has not yet been found to be admissible, and it is of a nature that could easily taint potential jurors. If the court denies his motion to classify, defendant requests an opportunity to file a public version of the motion that redacts the attached exhibits and details from the exhibit discussed in the motion. Defendant does not provide any specificity explaining why the potential evidence discussed in the underlying motion is of such nature that its disclosure could taint the jury pool. The potential evidence discussed in the motion is technical and discusses the process of scientific and forensic testing of physical evidence. It does not contain any obvious private or inflammatory information. And while the evidence has not been admitted at trial, there is no pending motion to exclude it. In balance, defendant has not provided a sufficient basis for the court to find that the interests favoring closure outweigh the interests favoring an open proceeding and the presumptive right to access. Moreover, as the Utah Supreme Court recognized, even in highly publicized cases, a defendant's right to a fair trial can be protected through the regular, time-honored process for selecting jurors, like enlarging the veneer of potential jurors, utilizing a detailed juror questionnaire, and conducting a thorough voir dire of potential jurors. Defendant's request to classify the motion filed on January 9th, 2026 is respectfully denied. As it relates to the motion to classify motion to exclude, docket 310, defendant seeks to classify his motion to exclude cameras from the courtroom because the motion compiles a litany of unfairly prejudicial and oftentimes inaccurate electronic media interviews, comments, and photographs. Furthermore, the motion references court filings that are classified as private and references the publication of private information of individuals involved in this case, allegedly in violation of law. Defendant does not provide any citations to the underlying motion to aid the court in identifying the potentially private information. The court is sensitive to the amount of pretrial publicity generated by this case, including an extensive amount of public commentary and inaccurate or conspiratorial descriptions of alleged evidence supporting or negating defendant's guilt. A substantial amount of this pretrial publicity is organized and memorialized into defendant's motion. Because the references to pretrial publicity are, by their very nature, already contained in the public arena, interests favoring closure are greatly diminished. And this citing to State v. Algier. The public already has access to the majority of the information contained in the motion. Upon balancing the interests at play, the court determines that defendant has not shown that the interests favoring closure outweigh the interests favoring access to the record. With the exception of the potentially private information referenced in the motion to classify, the court orders defendant to file a version of his motion to exclude cameras, referencing docket 305, that redacts private information referenced but not specifically cited in his motion to classify. The redacted versions of the motion to exclude cameras must be filed with the court by the end of business on March 30th, 2026. If no redacted motion is filed by that time, the court will reclassify docket 305 as public. If a redacted motion is filed, the court will maintain the private classification on docket 305. Accordingly, defendant's motion is granted in part and denied in part. Finally, turning to the defendant's motion to classify reply, docket 400. Defendant seeks to classify as private his reply memorandum in support of his motion to exclude cameras from the courtroom. Defendant argues that his reply memorandum should be private because it references portions of the motion to exclude cameras, which he has also moved to classify as discussed in the ruling on docket 310. Defendant does not cite any part of the reply memorandum that references potentially prejudicial information in the motion to exclude. Based on the record before it, the court concludes that defendant has not provided a sufficient basis for the court to find the interests favoring closure outweigh interests favoring access to the reply memorandum. As such, defendant's motion is respectfully denied. I will go ahead and sign this order, and it will go into the record. With this in mind, counsel, how would we like to proceed? What I want to turn to next is this upcoming April 17th hearing, how it will be conducted, and so we all have a good idea of what to expect and to prepare for. And so first, I'll hear from defense in regards to your expectations on moving forward, given the ruling of this court, and then I'll turn to the state as well. All right, Mr. Burt.
So, Your Honor, we anticipate calling several witnesses. One witness would be in the nature of a foundational witness who would summarize for the court the nature and extent of the publicity. Would be testifying to certain things like publication, scope, number of times certain articles have been referenced. We would be playing for the court the various clips that are referenced in the motion as well as others not referenced to provide the court with an overview of what we think the court needs to look at in terms of the nature and extent of the publicity. Then we would also be producing a expert witness whose declaration has already been provided to the court and to the parties. And that expert would testify to the facts and opinions outlined in the declaration that is attached to document number 305. We'd also have a third witness potentially who would be testifying to laying a foundation and testifying about a public opinion survey that is in progress right now. And that would be the extent of our evidence.
All right, thank you, Mr. Burt.
Sure.
To the state.
Thank you, Your Honor. Chad Grunander for the state. I would anticipate that the state would be calling one witness, and it would be in the nature of a foundational witness to just talk about the nature and the extent of publicity that is negative towards the prosecution and or negative toward Mrs. Kirk. And I believe that would be the extent of the evidence that would be presented from the state's side.
Thank you. All right, any other input from other parties?
Your Honor, the media does intend to be there, but we don't intend to try to complicate matters. We'll be there to make argument, as would be helpful to the court and to protect the interests that media believes may not be addressed in the other argument, but we will sit on the side table there as well.
All right, thank you. Thank you to all parties. I appreciate that information. Given the detailed motion filed on that January 9th, the court will read and prepare as it already has for that, and so the court finds it unnecessary to present all that evidence verbatim. The court does not need to see the video clips, and if defense wishes to give summaries of what's in the motion, the court allowed the overlinked memo to be filed with the intent of allowing you that ability to put in detail what you want to be considered and include your argument. And so the court accepts that and receives that and will review it thoroughly. But for the benefit of this hearing coming up, the court does not feel it is necessary to replay what is listed in the motion. Again, if you wish to give summaries of that, I understand that's going to your argument, but to go through it all again as detailed in the memorandum is not necessary for the finder of fact, the court. And so I will, that is one of the guidances I wish to give. In regards to the witnesses, that is fine. What I would ask is that your witnesses be succinct, on point, and let's stay focused on the issues that are before us. My fear is that we start veering in other areas that are not germane to the issue that's before the court. And this goes for both parties. I'm looking at Mr. Burt, but I equally am considering the state as well, because you indicated you're calling a witness. And so I ask that you prepare that witness to stay on point and to focus on the main issues that is before this court. We are scheduled, I believe it is April 17th at 10 a.m. And so we do have the remainder of the day. That being said, just because it's there doesn't mean it needs to be used. I want us to be focused and addressing. I also wish to encourage the parties to give your argument the weight that it deserves. This is an important issue, and I encourage both parties to be fully prepared and argue it. This is an important issue. I recognize it for both Mr. Robinson, for the state, for victim representatives, and for the issues of open and transparent courts. So the court is prepared and will be prepared at that hearing to hear the arguments, and I anticipate, unlike today, I will not be issuing a ruling on that day. I believe that what will be argued, the court needs to let it percolate, to examine, re-examine the motions, re-examine the notes, to ensure that the ruling the court makes properly balances the constitutional rights of Mr. Robinson, Ms. Kirk, and the concepts of open and transparent courts. With that in mind, counsel, is there any other issues that we need to address? Mr. Burt.
Your Honor, two questions. We had anticipated filing with the court either a disk or a thumb drive that contained all the reference electronic media cited in the motion. I assume from what the court said, the court has no objection to that.
No. And well, to the state, any input on this request from defense? All right. Mr. Grunander is submitting on it. So I'll accept that and I'll receive that to review, just to ensure, because sometimes URLs change, and so I appreciate you providing that so the court has a single place to refer to.
Sure. The second issue, Your Honor, I came across when I was preparing for the hearing today a letter brief that is online, dated October 28, 2025, from a group called Human Events. And it's addressed to Your Honor, and it's in the nature of a brief on the closure issues we've been discussing today. It indicates at the bottom that it was CC'd to the parties, but discussing with the prosecution, neither party has actually received this. I was curious as to how the court handles, if it does, letters of this nature where people are, unbeknownst to the parties, providing opinions, and in this case, legal briefs to the court, which I assume the court is not looking at, but I wondered, we don't see this filed in the docket.
Right, so that would be ex parte communications.
Right.
And the court has not reviewed that. Do we have a record of that? All right. What is the request of the parties? We have a record of it. I haven't reviewed it. It wouldn't be proper for me to do so, so I have not. What is your request as it relates to that particular brief?
As long as that's the court's ruling, that was our concern. Okay. And just to make clear that in fact is the rule, is what we were after.
All right, thank you, Mr. Bird. I appreciate you addressing that.
Sure.
To the state, any final issues?
Just briefly, Judge, there has been discussion today about the status of the April 17th hearing itself, whether it will be open or closed or portions of it. I'm assuming that that'll be addressed first thing on April 17th?
It will. I wanted to see if the defense wishes to file that motion in private that the court referenced in its order, and then I'll take it from there to see if there is private personal information that is anticipated being argued. And so I want to make sure that that's fully vetted out, that the parties see, and that we can prepare. I don't want to simply say it is. The presumption is it will be open, but could there be a portion that's closed? Absolutely. I just don't want to state how much or how long, because I don't know what the depth of that information. So I want to review that, but the anticipation is it will be an open hearing. And again, if there is a portion that dictates that closure is appropriate after balancing all the factors, then there will be a closed portion. Thank you,
Understood.
Mr. Commander.
Thank you, Judge. And then lastly, Mr. Novak did forecast a motion with respect to the preliminary hearing. So I don't know if we're going to discuss that further today. So
that's right, Mr. Novak. You talked about that. I said we would revisit it. At this point, what I anticipate is let's go ahead and brief that so it's fully briefed. Right now, it seems a bit premature because I'm not sure when that information is going to be passed over to the other side, how that affects how it's processed and reviewed. And so I'm happy to set a briefing schedule. It sounds like both parties are aware that the scope of what discovery could be coming over, but may not know all the details because it hasn't been passed over. Mr. Novak.
So that's fine. We're happy to brief it, and I think we should, in the time permitting, set a schedule so that
Absolutely.
The court can rule on that before its schedule gets worse. What counsel for the state told us yesterday is that they hope to receive certain materials in the next week or so. We also received yesterday, separate from the forensic sciences, a hard drive that has the images of all of the seized devices. Okay. At least one piece of evidence that I think that the state wants to present at the prelim is somewhere in one of those devices in theory. The state may have another way to present some of that evidence, but we don't know yet. So that's like an additional piece of that. And we, of course, haven't opened that box. We haven't sent it to the right expert. We do know that once we get all of the ATF case file materials from their forensic work and the ATF and FBI data files that we don't have from their forensic work, that it's not just about counsel receiving this, obviously, Your Honor. There's nothing that we can do, for example, with proprietary scientific data that has to be run through software that our experts have access to. So it's not like, oh, we got some information, we're ready to go. That's just what if I didn't adequately express that this morning, I wanted to do that. So we can brief it. It sounds like it should start with Mr. Robinson's motion to continue. And I guess the question is, working backwards, when does the court want to hear that motion?
Well, I certainly want to address it before the preliminary hearing itself, right?
Sure.
That would be appropriate. Well, how quickly could you have that motion filed? I guess that gets the train on the track.
I think it could be fully briefed if everybody is cooperative about that, so that it's ready for submission before April 17th.
All right.
Okay.
All right. So
I mean, that's basically a month and a couple days to brief a important but discrete issue.
Of course. And so is that, how much time would the state need to respond?
We could do it in a week.
All right.
I know the rules allow 2 weeks, but with the truncated schedule, we can do it in a week.
So the 24th of April, that would be the preceding Friday. So
I was suggesting, if I may, that we would fully brief it so that when we are here in person with Your Honor on April 17th, the court can hear argument if necessary and issue a ruling.
Oh, so are you saying your motion as well as the other side, or what's, I want to make sure I
I'm
understand.
saying that we can file our motion. Let's just say we need 10 days from now, or maybe
Okay,
two weeks to file the motion. And the state's saying they have a week. Maybe we have a few days for a reply as necessary, and it's submitted sufficiently in advance of April 17th, since we'll be here on that day, for the court to actually hold a hearing on the motion to continue.
I see what you're saying.
Does that still make sense to everybody?
So for clarity, you'll have your motion filed within 2 weeks, which is March 27th. And then state can have its reply by April 10th. And I think that's what Mr. McBride was alluding to. And then on that April 17th, the court will be prepared to hear argument on that as well.
I think Mr. McBride said they need a week. We want to file a reply, although we won't need a week to do a reply.
Okay, so I see. So from the 10th to the 17th, if you wish to file your reply of April.
Our response, April 3rd.
Okay. And then by the 10th?
Definitely.
All right.
So it's the 27th, the 3rd, and the 10th.
That's correct. I appreciate the parties working together to flesh that out, to address that. And then so as it relates to the April 17th hearing, that will be an additional issue that we address as well. And we do have the benefit of the day, so we can proceed accordingly. Anything further?
No.
Not from the state.
All right. And to defense, I'm anticipating Mr. Robinson will be here in person for that hearing?
Definitely.
All right. Thank you. All right, counsel, I appreciate your hard work today and your arguments, and we have a good path moving forward, and we'll address the issues on April 17th, and I'll look for those briefing on the 27th of March, 3rd of April, and 10th of April as well. With that in mind, court is now in recess.
Hey. Okay. They tell me it sounds good. Thank you for your help. I really appreciate it. I just noticed that there's like my phone messages that were going through. So I would love to leave with this, but I don't want to play so. I know that it was, and it's I'm at 3.
I see what you mean, like the feel good stuff. Or maybe scandal. Those two. Those especially. Oh yeah, we were all over that. It's sports related.
You gotta say no, and then I said more soccer.
Oh, really?
You know, if you don't have a height, then certainly they can sit on a little less, but yeah, very
Tim, do you hear anything on your IFB?
Just to let y'all know, I'm gonna be going by here in a minute or so.
Okay.
Yes, so I've been doing that.
I'm going to go live at 5:57. It is now, but do you hear anything in your earphones? Okay, so they're not like talking. I heard what he said. And when you say a second ago, do you mean before I asked if you heard anything? Okay, but they're like in a break right now, right? I hear him. Okay, great. I heard Kathy. Okay, that makes me feel good. What? Yeah. What? No, we're streaming. There's sports or something. I'm about to be.
Just real quick, we're going to be on time. I said so.
Okay.
We're going to be on time. We're going to come in here. A couple of things are going to speak. And I'm going to call on you to get as many of your questions as I can.
Okay.
I got a little time limit on it, so I'm just asking that when I say, okay, that's it, that's it. Okay.
Any idea how long it'll be, Lieutenant?
We're going to start at, they should be walking in here at 5:50.
Okay.
We're starting at 6.
Okay. So you going long or not long?
I hope it's not long.
Okay.
You will be.
Me too.
You will be happy.
Okay.
Just don't yell at me a bunch of questions.
That was Vegas.
So you ready? Are you ready to go this?
is the countdown to the T's? Okay, so do you want the T's to end right when the countdown ends?
Yeah.
Okay. Cool. Okay. This is new, but let's see how it goes. Have you done this before? The countdown? I got it like, it'll be 5. It's like 5.
Set it up. Go ahead. Yeah, no.
Just to give it a little hype. That's fine. There's a press conference coming up.
Yeah, no. There's a million seats. On time. I was enjoying being. Yep. I was enjoying being seated, bro. Then I was getting sore from.
Yeah, that's true. Because I think they do the Fox News minute or something. Well, make sure it will. These guys might be about to talk soon. Yeah. Okay. Sounds good. All right, never mind. I didn't need to do it.
Hello, my name is Jennifer Runyon, R-U-N-Y-A-N, and I'm the Special Agent in charge of the FBI Detroit Field Office. First, our hearts continue to be with the Jewish community and the victims here in Michigan as they recover from this devastating attack. Thankfully, the brave officers and security personnel who protected the temple yesterday are recovering, and we continue to pray for their speedy recovery, their speedy healing. Acts of violence against houses of worship, schools, and our communities have no place in Michigan, and the FBI continues to work tirelessly to provide support for these families and to investigate the events that led up to this ruthless act of violence. Now I'd like to provide an update about this active and ongoing investigation. We are aware that there's been a significant amount of public reporting about the assailant. However, because we are only 30 hours into this active investigation, it would be irresponsible for me to speculate about his motive at this time. Our team has been working around the clock to ensure that we remain focused on providing confirmed facts about this investigation rather than uncorroborated speculation. The FBI continues to process the evidence we've collected from the temple, the vehicle, and surrounding locations. At this time, there are no new known threats to the community, and the FBI has no indications that this attack was connected to the shooting at Old Dominion University in Norfolk, Virginia. The FBI has forensically confirmed that the assailant responsible for carrying out this attack was Ayman Mohammed Ghazali, age 41, from Dearborn Heights, Michigan. He has no previous criminal history and no registered weapons. He also has never been the subject of an FBI investigation. As for the preliminary timeline of yesterday's events, here's what I can provide. At approximately 9:58 a.m., Ghazali drove his gray Ford F-150 into the parking lot of Temple, Israel. From approximately 10 a.m. to 12:15 p.m., Ghazali remained parked in his vehicle in the parking lot. No other persons or vehicles were observed associating with him. At approximately 12:15 p.m., Ghazali starts driving through the parking lot, and approximately 12:19 p.m., Ghazali drives his vehicle into door 5 in the southeast corner of the building, hitting a security guard on his way in. At approximately 12:20, Ghazali's vehicle gets jammed between hallway walls, and he begins firing through the windshield of his vehicle. Ghazali and the first security officer engage in a gunfight through the rear window of Ghazali's vehicle. And at this point, Ghazali is unable to extract himself due to the vehicle being jammed in the hallway. At approximately 12:22 p.m., a second security officer engages Ghazali in a gunfight from the front of the vehicle. And soon thereafter, Ghazali's vehicle, his engine compartment, catches on fire, and at some point during the gunfight, Ghazali suffers a self-inflicted gunshot wound to the head. In the bed of the truck, we found large quantities of commercial-grade fireworks and several jugs of flammable liquid we believe to be gasoline, some of which has been consumed in the fire. Again, I'd like to commend the teachers and the staff who successfully evacuated children during this attack. We realize this is a traumatic event for everyone, and as a result, we have set up the Family Assistance Center to provide victim services support and resources here at the J Detroit for any individuals affected by this tragedy. For those looking to recover their personal items that were left at Temple, Israel during this attack, you and your family can recover your items here at the Family Assistance Center at the old fitness area of the J throughout the weekend. For the public, I continue to ask everyone and anyone if you have any additional information about the subject or this incident to submit a digital media tip at www.fbi.gov/West Bloomfield attack, or to call our tip line at 1-800-CALL-FBI. We ask that you continue to provide any information that you deem helpful, no matter how small you think it is. Additionally, if you or someone you know, a family member, a coworker, or a friend, is exhibiting concerning behavior or making threats towards themselves or others, please call your local police department or the FBI, once again, at 1-800-CALL-FBI. We need the community's help to keep everyone safe. I would also like to thank our state, local, and federal partners, along with the Jewish Federation, the Jewish Community Security, and the Temple Israel Security, as well as the local community, for all of their collaboration as we continue to work this investigation. Our partnerships and efforts are focused on keeping these communities safe, and we cannot mitigate or fully investigate these incidents without their tireless support. Lastly, I just want to leave you with this. The FBI will continue in our no-fail mission to defend the homeland against those who intend to create fear or harm. And I also encourage all of our places of worship to remain vigilant. I'd like to encourage our houses of worship and schools to work with their local, state, and federal partners to get active shooter training, such as the FBI's Active Shooter Attack Prevention and Preparedness training, to ensure everyone is protected while our first responders arrive to stop threats. At this time, I'll turn it over to Sheriff Bouchard.
Thank you. First, I'd like to say thank you to everybody that did respond, state, federal, all of our partners. There was a total of 605 law enforcement officers that responded to the scene from 42 different agencies. That's the way we work in this area. You know, time and time again, you see things on television, on TV shows where there's animosity between agencies. We don't see that here. We have a shared mission, and that's to keep the community safe. It operated seamlessly. Everybody came from wherever they could. And one of the things that's amazing to me, given that you had 605 law enforcement coming here with breakneck speed, there was only one accident where one detective on the way here, lights and siren, had an accident, and that person will be okay. So that's a miracle in and of itself. I'd also like to say that a total now of 63 law enforcement officers were sent to the hospital as a result of the smoke inhalation, the situation when the car caught fire. They continue to pour into the building to make sure, A, that the threat was neutralized and there was no follow-on threat, and B, the innocent were evacuated. They accomplished that seamlessly with the great work of not only the security team, but the staff that knew how to marshal these young kids and get them moving, a group that knew what to do or how to do it. They relied on the staff that was there to get it done, and they did it in a great way. So that doesn't come by accident. I mean, we talked a little bit about this before, training. We have all been training together for many, many years. Sadly, we have responded to multiple similar kinds of events around the county and in Michigan where active shooters were. And it comes from that deep training and participation and a willingness to help each other to be better prepared to respond to things that sadly we have to in today's world. So as you saw this play forward, again, it's not a time to make a plan at the door. That's why you have to train in advance, communicate in advance, and then execute when something like this begins to happen. Security did a great job. Staff did a great job. First responders did a great job. And it doesn't come without training. There's been questions about, well, it's kind of coincidental that there was training at the temple fairly recently, and is it connected or was there something suspected? The answer is no. We're training all the time as agencies with our partners, with our houses of worship, with our schools, and that was one of those such trainings. There was no credible intelligence or belief that it was about to get hit, but it's ongoing training throughout the community, and they did a great job executing that training. Also, I'd like to thank the community at large who has really poured out their support and affection for everyone involved. The Jewish community, first and foremost, has been, I think, uplifted and hugged from our community, and that's appreciated and is encouraged. If you know someone in the Jewish community, tell them you're with them. You stand against anti-Semitism. It's not tolerable on any level, anywhere, period. And also I'd like to thank, in addition to all of our partners, the Shenandoah Country Club and the Chaldean community, which served a lot of things, an incident command post and reunification center. They jumped right in and did everything they could and did that day, and they continue to do so to this day. And then finally, everyone here at this facility where we moved on day 2 has been amazing to make the facility and capability and staff available. It's those kinds of things. When you see the worst in humanity, you see the best. And we've seen the best in humanity respond to that here in this community. So I thank everybody for that.
Good evening, Dale Young, Police Chief of West Bloomfield Township. I want to start off by saying that I echo many of the sentiments that you just heard from both the FBI and Oakland County Sheriff. To my local, county, state, federal, and private partners, thank you for your invaluable assistance during one of the darkest days in West Bloomfield Township's history. To my officers, dispatchers, civilian staff, and fire partners, I am incredibly proud of how, without hesitation, you responded to this incident. You were pressure tested and demonstrated your readiness and the high level of your ability to respond to heinous acts of violence. To my West Bloomfield community, your Township Board of Trustees continues to invest in the professional development of its public safety personnel, to include equipping us with some of the best equipment in the industry. Your public safety is ready and vigilant to keep you safe. West Bloomfield, we will make it through this together. And with that, I'm going to turn it over to the Jewish Community CEO, Steve Ingber.
I said this yesterday, I'll say it again. I'm not surprised, I'm not shocked, and we've got to stop this. That's point blank. And I also want to remind my Jewish brethren that we are here, we will be here, we will come out stronger. We may be down, but we will reignite. Tonight is Shabbat, and I ask all of you to say a prayer. And I want to thank everybody behind me. And the 605 people that ran towards trouble. So when you're looking for a friend, when you're looking for who's with us, there were 605 people willing to give their life to save us. Thank God that didn't have to happen. May we all have a better day ahead.
We'll go ahead and take some questions now. Go ahead.
Hi, Corey at the AP for Chief and Sheriff Special Agent. If this guy drove from Dearborn Heights, he passed an awful lot of synagogues on the way. Is there a reason why he chose Temple Israel? Did he have any kind of connection with the temple or the congregation here?
At this time, that's still part of the ongoing investigation. I don't have any information to show an intent of why this synagogue versus another.
Special Agent, do you have any hard numbers on the number of rounds that were fired or fireworks found in the trunk?
I don't yet. Right now, we're still processing and assessing everything that we have and sending to the lab. Obviously, fireworks also, when they catch fire, they condense and smaller, so we're working on getting an accurate amount of pounds, and I just didn't want to put out any inaccurate information today.
Is it typical for somebody to sit in a vehicle for multiple hours at the parking lot? If so, I understand that, but if not, did security approach the vehicle while he was sitting there, or did nobody come up to it during that time while it was in the parking lot?
That's part of our investigation as well. Many people, I don't know how to opine right now on his motives, and so I don't want to speculate and give you any information. All I know is that based upon the surveillance footage that we had, he sat in the parking lot from 10 a.m. to 12:15 p.m. and decided to start driving after that. Okay.
Renelle Greer, the Jewish News. Did he have a self-inflicted wound as well?
Yes, ma'am. Preliminary reports from the medical examiner's office show a self-inflicted gunshot wound to the head.
To the head? Do you have a written copy of your statement, of what you said?
We can provide that. This is my media coordinator, Jordan Hall. He can make sure you get a written copy.
Okay.
Hi there, Kyla Russell with Local 4. You all just confirmed that the suspect was, in his car outside the temple there for a while. Do we know if he, and I've heard that maybe he has been to the temple a few times in weeks leading up, or in recent days? Can you speak to that at all?
No, not at this time. It's still part of our building out the full timeline and a part of that investigation, and I'm not going to be able to comment further on that.
Hi, Scott Walczak, Fox 2. Can you confirm when the truck entered and made its way, it ended up very close to where the kids were supposed to be?
Ask me that question again. Say that question.
Where did the truck end up in relation to where the children's daycare center was?
They were in a different part of the building.
Okay, different part of the
Yeah.
building. Okay, thank you.
We're told by some Dearborn Heights officials that the suspect recently had family members that were killed in an Israeli airstrike, but there's also reporting that those family members were members of Hezbollah, which has been designated a terrorist organization. Do you guys know that or have that information?
So we are aware of that information. That's definitely part of our ongoing investigation. At this time, I can't provide any additional on that or speculate further.
Because of the suspect's family members being killed in the strikes in Lebanon, we've been learning that some of his close friends and allies, they were actually contacting local law enforcement saying that the suspect was exhibiting some type of suspicious behavior. Is this anything that you all have been made aware about?
We're still pursuing every lead that comes into us, and at this point in time, I'm not going to add anything additional to that. I appreciate that question.
Hi, so are you treating this as a terror-related incident now?
So as I've said, we're just 30 hours into this, and we're letting the facts and evidence lead where we're going. And it's too early to speculate on the subject's motive. For the FBI, motive and inspiration is a key part of how we characterize an incident. At the end of the day, this is a devastating attack that was clearly targeted against one of our largest temples in the country. And we're pursuing every lead, and the FBI is working diligently. And when I'm able to provide that information in a confirmed way through the facts and the evidence that we have, we will provide that. But at this time, we're just referring to it as a targeted act of violence until we have further information to provide about his true motive.
This is going to be the last one. Tyler Keats, Civic Center TV. Given the number of religious institutions in West Bloomfield Township and in Oakland County, has patrol been increased or will it be increased at religious institutions throughout the weekend? Chief, Sheriff?
Yeah, I mean, we have increased it all across the county. I know Chief Young has definitely done that in West Bloomfield and has been doing it for the days and weeks prior to this, because we've been in communication regularly. And we actually communicated with our partners in Southeast Michigan chiefs today. And the resources are all prepared and all queued up, and there'll be extra attention to houses of worship throughout the region. So if you see police cars there, it's not because something's happening, it's because we want to make sure you feel safe to worship as you have the right to do in this community and in this country.
So this is going to be our last press conference for this event here. If we have new information that becomes available, you can find it either on the FBI social media account, or if it's something that's really substantial, we'll notify you for our next press conference. We want to thank you for your cooperation. You guys have been great during this time period. Hopefully everybody has a great weekend. Thank you.
Thanks, Lieutenant. Thank you.
Thank you.
We're good.
sure what they're getting is this. They're not getting that. So just don't trust this. It's not supposed to be a lecture. It's supposed to let you know that you're seeing something that you're supposed to be sending. What they're seeing is this. Yeah. The audio levels too. Okay, right? But it's showing it on both channels, even though one of them is up there. Really? So it's like, okay, that's you got stuff. You gotta get it. There's no menu. It's a mix. It's not. Because I monitored on the other end and it does separate it. But just the meter shows it as well. Just the meter. Separated separate. Yeah, but you tell it, it's just kind of meaningless. It's like, yeah, there's audio, but there's a reference point. You got audio channels. Well, here's the thing, if I turn off one, it will still show even those. And on the other end, we get so we'll show it too. So they can update this. How long does it last?
Thanks, man. Somebody wants the table. Oh, you guys, people might not have clips. We're moving the mic stand. We're switching over the other. The other one's lying upstairs.
Oh yeah, I got a.
Oh, you got a hook?
I do.
You use tape.
Every once in a while, I come prepared.
Oh, come on. Stop trying to
Yeah,
fake it.
I know. I try to keep my reputation.
I was willing to wait. I have tape too, if you want to tape it to the corner or tape it on. Of course.
Right? Yeah. Yes, that is good. Yes, that is good. There we go.
I found that if you tear it in half, it works a little better, and just use more. That's what I found. Of course. All the tape you want.
All right.
All I want is good audio.
All right. As Edison said, good enough.
Hold it.
All right.
Yeah, it's all the tape you want. Right, just go around and around and around until it stops. Good? Okay. You're good, I'm good. Thank you. You're welcome.
Thank you.
You got it.
It's not tight. It's all right. Yeah. It doesn't really. It's kind of.
Doesn't tighten?
Yeah, you see, it's kind of like right. It's like a fine line. A little bit. It's a fine line. Yeah.
Okay.
We'll get through. We'll get through.
How many did you say? I was here. I don't need Jesus.
I'm not a fan of that. On one kind of level, yeah, but this needs to find a place. That's how most people do.
think everywhere, even here in Tel Aviv, it's like this, but also here in the West. This Wednesday, for another while, but you see, we're back in. Look how everyone, he was trying to move the red carpet.
Yeah.
You can see he's trying to take a real. I know Arafat was yeah, he was in front, but it's funny because now you see like the red, like everyone is like this. The red carpet is there, like they're crazy. But then we like after, yeah, Arafat was like right, but you see, yeah, that's the red carpet. That's the red carpet. You see, it's all the ministers' heads. So I'm standing on the right wing of the my sister. That's where you see. I think that's more or less what it is. I won't say yeah, but then but you only go at 11 and then you finish at 4 or 5 hours. But there's a lunch near the trailer. So you eat before, but then you have next to the trailer there's like you get tickets and you have a hot dog. Yeah. So before you go on the red carpet, so 12:30 on the red carpet. But not the you don't want to make it easy on the first one. 12:30 open, but maybe 1 o'clock start people, and then 2, 3, 4, 3 o'clock they're last, and we don't get. I mean, because remember you have a lot of best short film animation, best documentary short, and we have a lot of people. You don't get the only couple is they will only go like entertainment and ET. I mean the big names, sometimes we get so you get a lot of other people, you get people you don't know. You get the that you so you get the because also we have clients in so many countries, so a documentary short, the French filmmaker, so it's important for us to get that. So you see we get a lot of people where you don't know who they are. So that's why we're on the show is we say, can you introduce yourself? So they say, oh my name is Miranda from Colombia and my short film is up next. I'll show you.
Herbert. Herbert.
Hey, it's Tony Zimbato in LA. How are you? Good. I'm on 145 Avenue 3. We're coming up for a press conference. Just wanna check it out. You should see my cars. Right. It's coming up. See the bars? No.
All right, we're done for the day.
Nobody's going to talk?
I doubt it. Just because there's... I'm going to go home.
Okay.
You can break down.
I'll wait for it.
Okay, just in case, sure.
What's that?
I'm going to move so I'm not watching.
Oh, it's the, social media. Let's go through it. Sure.
Do y'all want to hear anything from me, or can I leave?
Let's get a quick statement about how you're... how are you feeling about this?
The jury's already deep in work. We're appreciative of that. The judge is just so honed in on making sure the jury's time is maximized. We appreciate that. I think all the lawyers on both sides are working hard, and their staffs are working hard. We appreciate that. Everybody's going home.
Thank you.
Thank you, guys. Have a good weekend.
Thank you very much. Appreciate it. Q105.
I have something very important to say today. I'm in front of the courthouse, and I look good.